Why is it appearing as to be mentioned? Listed as to be mentioned?
I have mentioned yesterday. Kindly see the order dated 29th of 29th of January 2024, 5, madam. At their order, madam, direction was passed upon the investigation agency to submit the report fortnightly basis, madam. It was the direction. Paragraph 14, 15 of that order, madam.
এই রিপোর্টটা পড়েছেন এটা ফেলে
So this report has not come.
Well, report already come, my lord. But charge sheet has been submitted, my lord. So, my lord, there is no necessity of further report and all these things, my lord. This is the final report, my lord, and the tag with the charge sheet, my lord.
Yes, if charge sheet has been submitted, then
Yes, my
no
lord.
further.
Yes, my lord.
Wait
So,
for the petitioner.
petitioner, my lord,
Jaideep
actually,
Kanta
my lord, Jaideep Kanta Bhowmik is the petitioner, my lord. The bail petition has been turned down by the coordinate bench of this court, my lord.
You are for the? I see.
As per the direction of the honorable court, my lord,
So
the
after
sheet has been instituted, and accordingly, my lord, investigation has been done, and thereafter, my lord, charge sheet has been submitted, my lord. This is the final report, my lord.
Yes, but bail prayer has been rejected.
The bail prayer has been rejected.
On that very day,
After rejection, the
29th
bail prayer
January.
is
Directions were given.
yes, my lord.
Bail prayer was rejected by the same order or earlier
Same
order?
order.
Same order,
29th of
my lord.
January.
Same order. 29th of January 2025, my lord.
Anticipatory bail.
Yes, my lord.
And bail also.
And bail also, my lord. One and anticipatory bail and one bail.
Oh, I see. Acha. Proshenjit anticipatory bail and
Pradeep is
bail.
bail.
Show me the rejection of the bail, anticipatory bail I have seen.
Yes, my lord.
Where is the bail prayer rejected?
On my lord, what is it? 863. What are না বেল প্রেয়ারটা এনডিসি বেলটা তো ঠিক আছে, বেল প্রেয়ারটা একই অর্ডারে কি হয়েছে, একই অর্ডারে হয়েছে
But CRM DB 6/2025. 6/2025. DB একটু kindly বের করে দিন।
হ্যাঁ ঠিক
Separate order.
Yes, madam, separate.
But in the last line, my lord, mention the
Yes. Very well. So therefore, this fortnightly report is no more necessary.
already
And
charge sheet submitted.
these applications are pending.
Application not pending, my lord.
Disposed of.
Both are disposed of.
Disposed of by which order? Same order?
Same order.
Same order, madam.
তোমার কি দেখাচ্ছে? ডিসপোজ দেখাচ্ছে? ঠিক আছে, এসো। একসঙ্গে অর্ডারটা করো যেরকম আছে। These two applications for anticipatory bail and bail were rejected by a coordinate bench on January 29, 2025. Stop. However, the bench directed the Commissioner of Police Capital to constitute a special investigation team, Capital, to be presided over by himself and comprising of specialized officers in tracking and analyzing electronic evidence. Stop. The Commissioner of Police was directed to submit reports before this court on a fortnightly basis with regard to the progress of investigation. Paragraph. Today, learned advocate for the state, learned APP, tells me that investigation is complete and charge sheet has been submitted. Stop. Therefore, fortnightly report need not be filed by the Commissioner of Police anymore. Paragraph. I see logic in the submission made by learned APP. Since final report has been filed upon completion of investigation, the Commissioner of Police need not file fortnightly reports any further as he was directed to do earlier.
Grateful.
But one line kindly added, my lord, the report and the copy of the charge sheet.
Oh, copy of the charge sheet, paragraph filed in court today.
Yes.
Be kept with the records.
Yes.
Grateful.
Today, sir, on behalf of the petitioners, I filed out some documents with a list of documents.
Yes, what? Yes, tell me, what do you want?
In this case, sir, I'm falsely implicated in this case. Because of
All of them say so. False implication.
false implication. that-
Sure, yes.
Yeah, I'm totally sure, sir. That's why they are submitting some document with the list of documents.
Yes. What was recovered from you? What was his
So
from?
he is the main kingpin
No.
and he engaged the persons to drag and he is the persons and thereafter
What material is there against him in your case diary?
case study, he is the owner of the vehicle,
Owner of the vehicle,
yes.
registered owner.
registered
You
owner.
have that document?
Yes, lordship, I have the documents. I have the
And what was seized from the vehicle?
from the contraband of ganja.
How much, sir?
Lordship, see. 223 kg of ganja.
223. Then from your vehicle,
And he,
where do you practice? This ER business will not do in High Court. Yes, your vehicle, 223 kilos of ganja.
I am just in this case, sir. I am only for a legal owner. Today, which paper I am filing the court. If the honorable court was go through the records. So, honorable court is find out. The concerned vehicle, I've already sold in the year 23. 14th of March 2023. I've sold the vehicle. For the person, Mr. Raju Kumar. Mr. Raju Kumar. I've sold the vehicle. But in the meantime, Mr. Raju Kumar is not fulfilled all the term and conditions in prescribed time. That's why my name is engaged in this case.
Procedure 2025 shows that the registered owner is Ganesh Roy. And not only that, he is misleading the court and after granting the 438, did not turn up to meet the IOs and
438 was allowed in its
allowed interim to on condition to meet the IO. but after getting 438, he didn't turn up. Only a few days just turn up, thereafter didn't turn up. And thereafter
In this matter, he was granted interim protection.
protection, and subsequently it was vacated by the coordinate bench of Justice Tenton, your lordships. 12/3/25. Owner's detail I have already given. Is taking all the plea, not cooperating.
I see. For 6 weeks, he was directed not to be arrested.
Yes, and subsequently it was vacated.
Subsequently,
It is vacated, your lordship. Order has been vacated, lordship.
Vacated?
Yes, vacated.
he did not meet the investigating officer.
No, and not cooperating. Not cooperating, a misleading statement, tower locations,
I'm always.
and all the plea and
Copy the police concern, sir.
Anyway, sir, such huge quantity of ganja, I am not inclined. They should.
lordships.
Yes, sorry.
Please, sir. Go to the documents once, sir.
Yes, I've glanced. I've glanced. The petitioner says that although the vehicle from which 223 kgs of ganja was seized, comma, is still registered in his name, comma, he sold the vehicle to one Mr. Raju in 2023,
14th of March.
in March 2023. Stop. He has no connection with the contraband items. Stop. He has been falsely implicated. Stop. He prays for pre-arrest bail. Paragraph. Learned State Counsel strongly opposes the prayer. Stop. Paragraph. I find from the records that on January 22, 2025, comma, a coordinate bench had granted interim protection to the petitioner by directing that he shall not be arrested in connection with this case for 6 weeks or until further orders, whichever is earlier, on condition that he shall cooperate with the investigation and report to the investigating officer once in a week until further orders. Stop. Learned State Advocate tells me that the petitioner never cooperated with the investigation nor reported to the investigating officer. Stop. In any event, comma, that order was not extended subsequently. Stop. Paragraph. In view of the huge quantity of ganja involved, and given that the vehicle from which recovery was made is still registered in the name of the petitioner, comma, keeping in mind the restrictions in section 37 of the NDPS Act, comma, I am not inclined to entertain the petitioner's prayer for anticipatory bail. Go and surrender, obtain regular bail if you
Highly
can.
obliged, your lordship, highly obliged. Highly obliged.
Charge sheet filed.
Just a bit.
Charge sheet by the prosecutor.
Very well.
Item 4.
No, I'm for the state in 4, madam. Well, the report has not been received yet, my lord. Investigating agency has taken back the CD. They will submit the report together with the CD, my lord. Stay is also operating. Stay on arrest, my lord. No coercive action to be taken. There is a direction.
There was an interim protection granted,
Yes, my lord.
although
Not to
the
arrest.
order says petitioner shall be arrested.
No, subsequently this was corrected. I think.
Corrected.
This was a type error, my lord.
Yes. Yes. This was extended.
This was extended by Honorable Justice Tandon's bench, my lord, and thereafter,
So then I'll have to extend it. What to do?
my lord, I am unable to produce the report right now.
Read order dated March 12, 2025. Paragraph. Learned State Counsel says that the chemical report is still not available.
Right.
Stop. Let the investigating officer, but shall I direct the director of the laboratory to make it available? That's what we do in
My lord,
Calcutta all
my
the
lord,
time.
as your lordship.
আচ্ছা একটা কাজ করে দাও লেখো নেক্সট কেটে দাও নেক্সট কেটে দিয়ে লেখো which laboratory is this?
This is not.
You don't know,
I don't
Then
know.
how can I help you? তো দেখো let the investigating officer file a status report on the next date. Stop. List the matter once again next week Wednesday next
My lord. Eight. Ninth. Ninth, my lord.
9th April 9. Stop. Paragraph. The interim order that is in subsistence shall continue till the end of April 2025 or until further order, whichever is earlier. End of April 2025. That was 6 weeks. He had extended. Let it be end of April. Matter is being listed on Wednesday. We'll see.
My lord.
আর আরেকটা অ্যাড করে দাও তো the investigating officer is directed to make all endeavors to collect the chemical report prior to the next date so that the same can be placed before this court on the adjourned date. Mr. Vishash, ask your IU
My lord.
to make all
I
efforts to.
will personally communicate.
Yes, can be, but are you there on 7th?
Yes, my lord. Seven I will go. Seven I will go. I mean 5 or 6. Oh, seventh.
7th করে দাও
আমি কি মামলা দিচ্ছি কোনো মতো পরে মামলাটা আমার আছে।
I'm appealing for the petition, Lordship. The allegation is that the prosecution case has been started for cultivation of gaja. The petitioner happens to be the recorded co-sharer of a plot of land which is undemarcated,
Yes.
and allegedly gaja plant was seized from the
How much?
Commercial quantity. my lord.
25 kg gaja plant.
You are a co-owner of the plot.
Owner of the plot of land, and only I have been implicated in this case, whereas the plot is undemarcated. My presumption, my contention is that how they presume that it is my part of the land, and the
My lord,
Charge sheet filed.
and
no,
Lordship,
my lord, investigation going on and land department officials were they accompanied the raiding party, my lord. They have demarcated the land there. There was an initial report. Subsequently, record of rights are in his name. Those were found in his name. We have seized those documents.
Lordship, may I hand over the ROR kindly?
Now, this description from the description is clear that the land belongs to him. He is absconding.
It's demarcated
Lord.
land.
Yes.
Demarcated land.
Undemarcated it's.
No. They have a report. Share is.
I am only the co-sharer of a plot of land. The land is
Exactly
the land measure about 6 decimal.
Good enough that you are a co-sharer. It's a family business.
No, Lordship.
Growing ganja.
Actually, it's totally concocted allegation, and there is no eyewitness.
There has been seizure. Why do they falsely implicate you? What enmity does the state have against
Lordship,
you?
Very unknown reason. The reason.
Unknown
Always
reason.
unknown reason.
Lordship.
You have to tell us. Unknown reason, issue.
Lordship, kindly appreciate the FIR, Lordship, kindly. The investigating officer, the complainant states that few plots of land or cultivation of gaja were noticed. Astonishingly, only one plot of land has been found, and that belongs to me, and which is undemarcated. Not only to me, it is along with the co-sharer.
Description of the land.
Kindly
is given in the
comes to the third paragraph from the last,
description of land is given.
and
my
it
lord.
has been already been destroyed without the following the provision of the law. Section 48 has not also been complied.
Argue all
mandatory
that before the
provision.
trial court. The petitioner says that he has been falsely implicated. Stop.
কিছু করেনি।
Allegedly, ganja cultivation was being done on a plot of land of which the petitioner is a co-owner. Stop. It is an undivided oblique undemarcated property. Stop. The allegations are out and out false. Stop. Paragraph. Learned state advocate says that commercial quantity of ganja
Lordship, may I, Lordship?
was seized from the concerned plot of land. Stop. The petitioner is absconding. Stop. Paragraph. In view of commercial quantity of ganja being involved and undisputedly the land on which ganja cultivation is going on, was going on, is co-owned by the petitioner, comma. Also keeping in mind that investigation is in progress and charge sheet is yet to be filed, comma, I am not inclined to grant anticipatory
Lordship, may I
bail
something, Lordship?
to the petitioner.
Lordship, I think my learned senior is going in the wrong way. The cultivation of gaja, these alleged articles is not only gaja, it's gaja plant weighted above 26 kg of gaja plant, and it is not under the commercial quantity. Only the gaja is under commercial quantity.
Surrender, cooperate.
Lordship, kindly appreciate in this, Lordship, in this. The gaja plant is about
Next
26
one.
kg.
Item 6, I'm doing for short pass over. I have to produce one co-accused copy of bill, short pass over.
I am rather, I will prefer not to do this.
He is in difficulty, please
Malad,
appreciate.
Malad.
Either do it now or
Malad, I have one.
not today.
Well,
6.
One second, Mr. Shahaputra. Manoj, I'm interrupting one. This case, I represented the state in case of other accused persons also, my lord. So I am aware of the fact that who is on bail or not. I can assist your lordship on that point.
Number 6,
Yes, my lord.
Yes,
co-accused is on.
Yes,
has-
ma'am.
Yes.
Yes,
I
ma'am.
represented the state in the matter. I remember it very well.
তো করে দাও তাহলে
Malad.
দাও 6টা দাও
You don't have to. We cooperate. When there is a genuine thing, we cooperate. No problem.
what is it?
Attaching one accused person, villagers came, painting stone to the police vehicle, and apprehended the police person. This is the allegation against the accused person, or the co-accused person, granted and bail by the Honorable High Court, my lord. There is no injury on the police personnel, no damage to the vehicle also, my lord. I am standing on similar.
That is correct, Mr. Vishwas?
Yes.
What is this?
164 statement also, nobody is named, except names in the FIR, the names didn't appear in 161 statement. And there is a 164 statement, medical reports are at 35, from 35 to 38. my lord.
So this is one of the orders.
Earlier, my
Very well, since you say so. Let's not waste time on this. So you are claiming parity.
I think another thing, need may be directed to amend the first title in the name of the petitioner, one alias will be.
Leave is granted to learned advocate on record for the petitioner to correct the cause title of the petition for anticipatory bail. Paragraph. The petitioner claims parity, citing an order dated February 17, 2025, passed in CRM bracket A 88 of 2025 by a coordinate bench, whereby two co-accused persons were granted anticipatory bail. Stop. The petitioner says that he stands on the same footing as those two persons. Stop. His custodial detention is unnecessary. Stop. Paragraph. Learned state advocate, while opposing the prayer, in his usual fairness, does not dispute that this petitioner is similarly circumstanced as the aforesaid two persons who were granted anticipatory bail on February 17, 2025. Paragraph accordingly, on the ground of parity, this application is allowed.
One indulgence, the 164 and the medical report kindly refer.
Acha, while opposing the prayer, ওখানে যেখানে বলেছি, refers to the statement of an eyewitness recorded under section 164 CRPC as also the medical report. Stop. However, in his usual fairness, he does not dispute বলে যেটা আছে তারপরে। Petitioner is not there. Chalo, pass over. Yes. What are these sections corresponding to IPC? What are these?
329.
Sir, that I can see. Just tell me the offense.
559 and the SCST prevention of adults.
Very well.
What happened, my lord? The inhabitants of that locality, my lord, where the alleged incident, my lord, allegedly happened, my lord. Few of the inhabitants, my lord, were not paying the electricity bill that they have consumed. But out of that incident, my lord, the electricity department were not constrained to, my lord, organize a camp in order to spread awareness. On that day, my lord, these petitioners, along with others, who are willing to pay the electricity bill, my lord, they cooperated with the electricity department officials. Those inhabitants, my lord, who were not, my lord, willing to pay, my lord, they obstructed, they, my lord, assaulted the petitioner, and after that, my lord, the mother of the petitioner, my lord, lodged a complaint. That has been alleged, my lord, kindly come to page 11. Page 11.
Yes.
The petitioner has been, my lord, assaulted by those inhabitants, my
There
lord.
are three persons.
Page 11 is, my lord, the complaint that has been lodged by the petitioner's mother. As, my lord, those, my lord, inhabitants who are not willing to pay the electricity bill, my lord, they assaulted and obstructed us. But my mother lodged the complaint. But in retaliation, my lord, they have filed another complaint. After that, it has been lodged, my lord. My complaint has been lodged on, my lord, 4th of September 2024. And, my lord, the prosecution case against which I have sought bail, my lord, this is registered on 5th of September 2020. My lord, that is the, my lord, the actual fact.
Yes, madam.
behind, my lord, the prosecution.
Injury report is on page 39, which is a simple injury, Lordship.
Simple injury.
Yes, Lordship. And 164 is on page 35, Lordship.
The 164 to the issue. The petitioners say that the present complaint is a counterblast to an earlier complaint lodged by the mother of the petitioner number. Mother of one of the petitioners, Koro. One of the petitioners. Mother of the petitioner number 1. Mother of the petitioner number 1. Stop. There was an awareness camp organized by the electricity authorities to persuade the consumers of electricity to pay the bills. Stop. The petitioners cooperated with the authorities, stop. Other residents of the locality who were not willing to pay the bills, comma, took up a fight with the petitioners, stop. The petitioners were injured and accordingly a criminal complaint was lodged, stop. On the next date, the present complaint, false complaint was lodged, stop. Paragraph, learned state advocate has drawn to my attention the statement of a witness recorded under section 164 CRPC, as also the medical report, stop. The injury suffered by the victim is described as simple within inverted comma. Paragraph, on an overall assessment of the material on record, I am of the view that immediate custodial charge sheet filed, immediate custodial detention of the petitioners is not necessary. Is right to the other field. What is the nature of the offense here?
65, 64, 351, 29. That's not
Outreaching modesty. Yes. Plucking of flower.
Plucking of flower
You were plucking flower. No.
from my land, my lord. The company is making, my lord, trying to pluck flower. Because there was a altercation and after that.
Yes.
This is the 164 statement, Doctor.
No injury report, nothing. Is there a medical report? No.
The next page, Lordship, the medical report, no external injury was found.
No, this is allegation of rape.
Section 64. Not PNA.
Charge sheet.
Fine, Lord.
The petitioner says that he has been falsely implicated. Stop. The allegation is that the complainant lady was plucking flowers in the petitioner's garden and the petitioner molested her. Stop. This is a completely false allegation and will not be borne out by the material on record. Stop. Paragraph, learned state advocate draws my attention to the material in the case diary, including the statement of the victim lady recorded under section 164 CRPC. Stop. The medical report does not support the version of the victim lady. Prima facie does not support. Prima facie does not support the version of the victim lady. Paragraph, on an overall assessment of the facts and circumstances of the case, I am of the view, and seeing that charge sheet has already been filed, comma, I am of the view that immediate custodial detention of the petitioner is not necessary so long as he cooperates with further investigation, comma, if any.
One day accommodation CD not received by.
Not today. Very well. Learned advocate for the petitioner says that he has instructions not to press this application. Paragraph. করে দাও, dismiss করে দাও। এই petitioners হবে ওটা। 13 নেই, চলো চলো চলো। State. এই ইয়ে করো, লাইভ স্ট্রিমিং, হ্যাঁ। Bipul Rai has been granted bail on that basis. Here, issue. The petitioner says that no narcotics was recovered from his possession. Stop. He is in custody for? Sorry. Oh, they were granted bail. They were granted.
They were granted bail. His
Stop.
name, one of the co-accused has
Stop.
stated his name.
A co-accused person has been, two co-accused persons have been enlarged on bail. Stop. The petitioner prays for anticipatory bail. Paragraph, learned advocate for the state opposes the prayer for bail. Stop. However, in his usual fairness, he does not dispute that there was no recovery from this petitioner. And he has been implicated on the basis of statement made by co-accused persons. Paragraph, I have considered the materials on record. Stop. Since there was no recovery from the petitioner and co-accused persons have been enlarged on bail, comma, I am of the view that the petitioner has made out a case for anticipatory bail. Yes. Oh, state nahi, state?
He is not evident.
CD not there, not today.
Lordship, item number 18, same lordship, CD is not evident. 18.
18-year period, oh. Nineteen. Petitioner not here. Pass over. State,
So Subhashish Mishra is there. So pass over.
pass over.
91. I'm for the state, madam.
Petitioner not there. Oh, you are there. Yes. Of the vehicle, land.
No, it's the same, the previous one which was rejected, madam.
Same case.
Same type of case.
Okay.
Lot of land, house vacant land, and there is no implication that petitioner cultivated. This is my submission. There is no evidence that I cultivated the land.
Charge sheet filed.
Charge sheet filed on 25th of February 25. My lord, actually, it has been land which has been identified by the witnesses as well as the bailer also. This is the land owned by the petitioner. So no dispute about the ownership of the land.
Then,
Huge
sir,
quantity, my lord.
your
1045.
property, if you can't look after it, if it is misused, explain those things to the trial court. Or go obtain regular bail. Nobody stands in your way. No anticipatory bail.
No, after hearing it can be done.
The petitioner says that the land on which allegedly cannabis cultivation is going on, comma, although registered in his name, comma, is far away from where he resides, stop. He never had any control over the land, stop. He does not know for what use the land is being put, stop. He prays for anticipatory bail, paragraph. Learned advocate for the state shows me documents from the case diary clearly showing that the petitioner is petitioner is the owner of the concerned plot of land. Stop. Paragraph, in view of commercial quantity of contraband items being involved, comma, I am not inclined to entertain the petitioner's prayer for anticipatory bail. Paragraph. Who is for the statement, sir? Yes. No recovery. Yes, Mr. Vishwas, no recovery?
Yes, my lord, his name was disclosed from the statement of the accused as per the FIR, my lord. He is the one who had instructed for transportation of the narcotics. But ultimately, there is no recovery. from-
Yes. Uh,
Investigation has been completed.
The petitioner says that there was no recovery of narcotics from him. Stop. He has been implicated solely on the basis of statement made by a co-accused person. Stop. Investigation is complete. Stop. না, ওখানে লিখো না। Stop. He prays for pre-arrest bail, paragraph. Learned state advocate, while opposing the prayer, comma, in his usual fairness, does not dispute that there was no recovery of narcotics from this petitioner, and his implication is solely on the basis of statement made by a co-accused person. Paragraph, in view of the aforesaid, and seeing that investigation is complete and charge sheet has been filed, comma, I am of the-
5/2/2025.
filed on 5/2 on February 5, 2025. Charge sheet has been filed on February 5, 2025, comma. I'm of the view that it's changed the ringtone, not good. I'm of the view that immediate custodial detention of the petitioner is not necessary.
Lordship, item number 23, 26, 27, and 28 arising out of same case and separate petitioner, same case.
Yes,
Let it be take together.
yes.
The case diary is here.
Yes.
Let all the matters take.
Why,
together.
what, together? One by one, 23, yes.
Coming to the top. Now the petitioners are no convictions, lordship, the other two accused lordships have already granted by the. They are exactly similar thing by the coordinate date of this honorable court, lordship.
Caesar was from the house of Hamidul Haq. And Hamidul Haq has been granted anticipatory bail.
No,
No?
that Hamidul,
Baba, kota Hamidul Haq.
Father's name is Adjournment. A different person, madam. But I am giving the, my lord, the orders, lordship.
Yes, what do you say about Rejaul Haq?
actually, Rejaul Haq is a villager. What happened actually, the police raided the house of Hamidul Haq, son of Ainul Haq. And from his house, the contraband, psychotropic contrabands were recovered. At that time, there are some commotion with the police and the villagers. And the name of the villagers have been incorporated in this case. Actually, against them, the alleged sections are of 353 of that IPC.
So therefore, sir, there was no recovery from Rejaul.
No.
His name has been brought in on the basis of statement made by co-accused person.
Not even co-accused persons.
Then,
Actually, there was a commotion between the villagers and the police while they raided the house of
I
Hamid.
see. Hey, Yeshu. So he stands on the same footing as Ziarul Haq.
Yes,
Huh?
absolutely.
The petitioner claims parity, citing an order dated February 17, 2025, passed in CRM bracket A 92 of 2025, by a coordinate bench, whereby anticipatory bail was granted to one Ziarul Haq. Eta theke dekhe niyo, one Ziarul Haq. Stop. The petitioner says that like Ziarul Haq, there was no recovery from this petitioner. Stop. There, the seizure was made from the house of one Hamidul Haq,
Son of
son of
Ainul
Haq.
Haq.
Son of Ainul Haq. Stop. There was a commotion at the time of seizure where several villagers were present, including this petitioner. Stop. All. That is why the petitioner has been implicated. Stop. Paragraph, learned state advocate, while opposing the bail prayer for anticipatory bail, comma, in his usual fairness, comma, does not dispute that this petitioner is similarly circumstanced as Ziarul Haq, who has been granted anticipatory bail. Paragraph.
Objection kindly be noted.
Yes, while opposing the prayer. Yes. Opposing the bold capital. এটা করে দাও। Paragraph. Hence, comma, on the ground of parity, the petitioner's prayer is allowed. Anticipatory. করে দাও।
26. Lordship 26, 27, 28.
26, 27, 28 আগে নিয়ে নাও, continuity থাকবে।
হ্যাঁ।
Same.
Same.
শোনো, same order হবে, খালি নামটা বদলাবে petitioner-এর, otherwise same order.
26, 27 and 28.
ঠিক আছে, same.
27, 28. 26, সৈকত ছোট্ট line.
24 টা।
27.
24.
27, 28 নামগুলো দিন। Yes. I'm for the statement.
One for the limit to complainant and the short parcel. Paper short parcel.
Because started with section 304 of.
He's asking for a passover, sir. Why? You are not appearing in this matter?
No. Mr. George, come. No, no, put it.
I have not seen it.
Tell me what to do. Passover? Passover? Not today, not today.
না না আসবে তো 4 নম্বরে আসবে। এটা কি বলে?
25.
Petitioner নেই, চলো। Passover.
Not today then. Passover.
26. 26, 7, 8, 29, 29.
নেই। Passover.
30.
Yes.
30.
Gana. Why? Monday, Shivji's day.
31.
On the prayer made on behalf of the petitioner, let this matter stand adjourned and be listed again on Monday date দিয়ে দাও।
31.
31.
Passover.
32.
I'm for the state.
Yes, দাও।
নামটা দেই, নামটা দেই।
Yes, what is the nature of the offense?
Lordship, actually.
103 is there.
Lordship?
103 is there.
No, Lordship. Actually, all other co-accused persons granted, enjoyed liberty of anticipatory bail, Lordship.
What
Versus
is?
the modesty and the assault.
Oh,
Actually, they, Lordship.
all other persons, and
Except these petitioners.
anything specific, or he stands on more or less the same footing.
Same.
Same footing. The petitioner says that all other accused persons have been granted anticipatory bail. Stop. He has been falsely implicated. Stop. There is no material on record which would justify his custodial interrogation. Stop. Charge sheet filed.
A charge sheet filed and next date has been fixed for appearance. Here,
Stop.
warrant has been issued.
He is fully prepared to cooperate with the police authorities. Stop. Paragraph, learned state counsel, comma, while opposing the prayer, comma, says that all other accused persons have been extended the privilege of anticipatory bail. Stop. To my query as to whether or not this petitioner is similarly circumstanced as those persons, comma, he fairly admits that this petitioner stands more or less on the same footing as the other persons who have been granted anticipatory bail, other accused persons. Paragraph, I see that the charge is of assault and outraging the modesty of a woman. Stop. There's no injury report is
Your
there.
lordship, injury is here.
Simple.
Not simple, nothing has been mentioned, only that the
Nothing.
head injuries.
Stop. The injury report does not reveal much. Stop.
Head injury is written only and bleeding,
Charge sheet has been
filed.
filed upon completion of investigation. Paragraph, in the aforesaid factual scenario and considering the nature and gravity of the charge, comma, I am of the opinion that immediate custodial detention of the petitioner is not necessary so long as he cooperates with the cooperates in further investigation, comma, if any.
Grateful, lordship.
Hey,
I am for the state.
I want to not place the petition because the petitioner arrested already.
Oh, the learned advocate for the petitioner says that this application for anticipatory bail has become infructuous since the petitioner has already been arrested. Paragraph accordingly, comma, CRM, whatever, is dismissed.
Grateful, lordship.
Lordship, I'm for the applicant, Lordship, 34. This is a restoration application, Lordship, last location.
Lordship, praying for short possible, Lordship.
Last location, Lordship, directed to file opposition. They have filed opposition, Lordship. I'm praying for only 1 week time. Lordship, I'm for the applicant, item number 34, Lordship.
এটা কোথাকার কি চলে এসছে এখানে?
সেটা কি আপনি কোর্টের কাছে ক্লিয়ার করেছিলেন? দেখেন আমার ক্লিয়ারটা
দেখতে পাচ্ছেন না, একলা বসে আছে। Yes, 30 কি বললেন? 34 pass over? Pass over.
Lordship, I'm for the applicant, Lordship.
Madam, this is a single bench.
I'm for the state. 341, 323, 325, 307, 354, 503 and 34 of the Indian Penal Code. Corresponding to IPC, registered in IPNS. And total 4 persons are FIR named. Out of 4, 3 had been granted anticipatory bail by the learned session judge. I have arranged the order, and our dispute is, but the informant and his father were constructed bamboo fencing. At that time, they obstructed them, and that is for that reason, the land is.
Does he stand on more or less the same footing or differently circumstanced?
Lordship,
Do the witnesses implicate this petitioner?
yes, witness obviously implicated this petition.
What about the others who have been granted anticipatory bail?
Page 9 of the same footing.
Same footing.
And the injury report states that
hairline fracture cannot be ruled out.
Esho. Charge sheet?
Just is submitted, but the 109, that is attempt to murder, 307 of corresponding section of IPC has not been incorporated in the charge
Has
sheet.
not been. The petitioner says that he is one of 4 accused persons. Stop. The charge. Initially, the charge was of attempted murder and was of causing grievous bodily harm and attempted murder. Stop. The 3 other accused persons have been granted anticipatory bail. Stop. He stands on the same footing as those persons. Stop. He prays for anticipatory bail. Paragraph. Learned State Counsel, while opposing the prayer, apprises me that charge sheet has been filed upon completion of investigation. Stop. Charge under section 307 IPC.
Corresponding to 109 of BNS.
Corresponding to 109 section of BNS has not been incorporated in the charge sheet. Stop. Paragraph. I have seen the material in the case diary, including the injury report. Stop.
Injury report is explained.
Stop. I find that this petitioner is similarly circumstanced as the other accused persons who have been granted anticipatory bail. Paragraph. Hence, I allow the petitioner's prayer.
Not I for the petition. This is a case under section 316(3) of the BNS, there is a 420 of the IPC. The petitioners is working under the Muthoot Financial Corporation, and their work is that collect the EMI from the customer and submit it to the bank. And the allegation is that they have defalcated some amount and collected from the persons and did not submit at the bank. That is the whole allegation, my lord. But my lord, that actually what is the case is that, my lord, the petitioner have been give his resignation and did not went to his work.
There are 2 petitioners.
There are 2 petitioners. For that reason, my lord, the false implicated has been happened, my lord.
What material do you have, Mr.?
My lord, here is their
There are 2 petitioners.
2 petitioners, yes. Biplab Rai and Dipankar Chando.
My petition, only 1 petitioner is there.
Huh?
My petition, page number 2, only 1 petitioner is there. Biplab Rai, whatever it is. My lord, the alley. Maybe this.
Yes, in your petition, how many petitioners are there? 2.
I may pardon, my lord, some correction or mistake.
So now thing is that, my lord, there's a case, total amount is 4,94,515, which they have collected from various customers of the finance, Muthoot Finance, which has given loan, and there are several complaints also on behalf of the depositors. So they have received that amount from them, they have issued the receipt, and some loan accounts where there were foreclosures are also there, but they have not deposited to the bank. So there are many complaints. So serious in nature, my lord, because
Serious
this
in nature. Charge sheet filed.
charge sheet not filed. Charge sheet not filed.
So investigation is in
Is
progress.
in progress, my lord.
Sorry,
It's a
sir.
case of November 2000.
Not this
now
one.
there's, my lord, it is a fashion of the Muthoot Financial Corporation. If any person of their worker, my lord, give resignation, they have been filed the present complaint.
Very
My lord,
good.
kindly say, I have another complaint. If your lordship permits, I will give another 5 complaints, my lord. They have been, my lord, fraudulently, my lord.
Go and surrender, obtain regular bail. The petitioners say that they have been falsely implicated. Stop. They were collecting agents of
Muthoot Financial
Muthoot Financial
Corporation.
Corporation. Stop. Since they resigned from service, this false complaint has been lodged to the effect that they collected money from the customers of the company, but did not deposit the same in the till of the company, Paragraph. Learned State Advocate comma, with reference to the material in the case diary, comma, tells me that about rupees
4,94,000.
4.94 lakh was collected by the petitioners from the customers of the finance company, but was not accounted for. Stop. Therefore, comma, the charge is of defalcation of that amount of money. Stop. Charge sheet is yet to be filed. Paragraph. Given the nature of offense, comma, I am of the view that it may be necessary to interrogate the petitioners in custody. Stop. Therefore, I am not inclined to allow the prayer, petitioner's prayer, essay for apostrophe, of prayer for anticipatory bail.
Malar, I'm praying for 1 day accommodation.
But I'm for the petition.
38 state. Passover.
I'm for the petition.
State is not there, Mr. Poddar. Passover. Find out, bring him. Finish it off today.
40. What are for the?
Or 379 Marat, 411 and 413, 414 of the Indian Penal Code Marat offense. No allegation is that Marat on the basis of a source information, Marat the BSF participant they are performing a duty, NACA duty at that time Marat 3 and 4 persons Marat they are trying to smuggle the cattle in the Indo-Bangladesh border Marat. But that is the subsequently they fled away. They did not try to apprehend them, and what FIR has been lodged against 4 persons. But my name is transferred in the But we are the FIR named accused Malad, and Malad FIR has been started against 4 accused persons. And Malad charge sheet is submitted. We are my humble prayer is that my charge sheet is submitted, and kindly see we cooperate with the investigation.
Yes, sir. Investigation is over. What will you cooperate?
Face the trial, face the
Only
trial.
section 413, that is habitual dealing in stolen property. That is a success triable case, my lord. And in this is very, they are habitual, my lord. So that is the thing. And cattle, theft of cattle.
That is the allegation.
No,
Cattle of theft,
habitual,
there's a very-
habitual. Do you have material to show that they are
No,
habitual?
they're criminal antecedents.
Antecedents,
No.
then 413 may not be able to establish.
My lord.
Hmm?
And another thing,
Then report to usual conditions will be there.
Yes.
Report to you every week. তাই তো থাকে। Every week na fortnight কি এটা থাকে না?
charge sheet has been filed, even then they should not leave the jurisdiction. my lord.
Yes, I know.
Very well. The petitioners say that they are 3 out of 4 FIR named accused persons. Stop. The charge is of smuggling cattle through the Indo-Bangla border. Stop. Charge sheet has been filed upon completion of investigation. Stop. If further investigation is conducted, they will fully cooperate. Stop. They pray for pre-arrest bail. Paragraph. Learned state advocate says that section 413 IPC has also been invoked. Stop. The petitioners are habitual offenders. Stop. However, comma, the state could not produce any material demonstrating that the petitioners have criminal antecedents. Stop. Paragraph considering the nature of the charge and the fact that investigation is complete, comma, I am of the view that immediate custodial detention of the petitioners may not be necessary. Stop. Paragraph করে দেবে সব condition গুলো। শোনো,
Charge sheet has been submitted.
হ্যাঁ, একটা condition add করে দাও, not to leave the jurisdiction of what?
কোনখানে একটা
কোতোয়ালি
কোতোয়ালি PS, না?
কোতোয়ালি জলপাইগুড়ি
জলপাইগুড়ি
কোতোয়ালি
কোতোয়ালি police
Jalpaiguri Kothwali PS without the leave of the learned trial court.
station.
Yes, ma'am.
ওটা তো কালকে তো দিইনি বোধ হয়। Yes,
41. And I'm praying for not today, ma'am.
not today.
Not CD is not here. Well, 42 also same, but not today. 42 not today. Not 42.
Not to the lordship. Not to the lordship.
44, my lord, these are 376 case, my lord, I have served the part.
Not police mercy.
Our kindly make it next week, my lord, and serve the notice to the, my lord, IO. to the
Why, you have not
petitioner.
served?
But I have served, my lord, it was delivered, but they did not come, my lord. Earlier matter, you have, lordship directed the state to.
Learned advocate, where's your affidavit of
Yes,
service?
yes.
দাও তো।
Service. জজ সাহেব বলছেন ওদেরকে লিগাল এইড দিয়ে সার্ভিস দিয়ে
Mr. Ganguly, every notice henceforth should mention that they have a right to be represented through lawyer, to be engaged by the High Court Legal Service Committee, and they don't have to bear any cost. From the affidavit of service filed in court today, comma, it appears that the de facto complainant oblique victim may have received notice of this application for anticipatory bail. Stop. However, comma, the language of the notice is not to my satisfaction. Paragraph, let the state effect service and file service report on the next date. Stop. The notice to be served by the state shall specifically mention that the de facto complainant oblique victim has the right to be represented through a learned advocate to be appointed by the High Court Legal Services Committee, for which the de facto complainant oblique victim shall not have to bear any cost. When should we keep it? When should I keep it?
মঙ্গলবার
কোন কেস ওমেন উইথ দিনহাটা
মঙ্গলবার রাখো
Tuesday.
Tuesday বলো।
List the matter Tuesday.
Not every service kept on the record.
Affidavit service to নিলাম তো from the F2 করেছি।
Lordship, I'm on behalf of the lordship. Actually, Lordship, petitioner and the de facto complaint both are the village neighbors, and the quarrel took place due to the some incident has happened on 9 January that one goat entered into the petitioner land and eat some vegetables, and the quarrel took place. Quarrel took place in the sense that they use filthy language, abusing filthy language, and the modesty has happened. So that is only the
The de facto is a lady.
Lordship.
Her goat came to the petitioner's land.
Lordship. And some
Male goat or female goat?
no.
Yes, nature of injury.
My lord, injury report. Head injury with vomiting, my lord, at the bottom, my lord.
No hospitalization.
No.
Another co-accused
He was
person
taken to
also
hospital,
granted-
my lord.
granted
Discharged.
injunction.
Another co-accused.
Two co-accused persons granted anticipatory bail, Lordship, from the lower court, trial court, Lordship.
Charge sheet.
No, my lord.
I will cooperate with the investigation, Lordship.
The petitioners say that the incident was the fallout of the de facto complainant's goat trespassing into the petitioner's land and eating vegetable. Stop. A quarrel ensued, and there was exchange of fists and blows. Stop. Two other accused persons have been granted anticipatory bail by the learned trial court. Stop. They will fully cooperate with the investigating officer if granted anticipatory bail. Stop. Paragraph. Learned state advocate shows me the injury report. Stop. I've also seen the other material in the case diary. Stop. Paragraph. On an overall assessment of the material on record, I am of the view that although charge sheet is yet to be filed, the petitioners may be granted anticipatory bail so long as they cooperate with the investigating officer.
Lordship.
Grateful, Lordship.
সিঁড়িটা দিয়ে দাও।
Yeah, 46, 47, not today.
48.
Pass over.
49. I'm for the petition, your lordship.
Paying for 1 day, Lordship. Tomorrow, Lordship.
Your lordship kindly fix the matter 4th April.
4th April.
4th April.
Your birthday.
No, sir.
No.
I'm
On the
not available tomorrow.
on the prayer made on behalf of the petitioner, let this matter stand adjourned and be listed again. Petitioners করবে। ওই বললেন April 4.
4th. Get puller.
Okay, 50, no city, Lordship.
No CD. No CD, no petitioner. Oh, no, you are there. Not today.
Fifty-one.
नहीं, pass over.
52.
Passed over.
53.
Your lordship, I am praying for the matter to be kept on Monday because a senior counsel will come from Kolkata and he will be physically appear on the hearing day.
And who is the senior counsel?
Saurabh Chatterjee.
Very bad case. On the prayer made on behalf of the petitioner, let this matter stand adjourned and be listed again on কি বললো Monday. কবে? Monday কত তারিখ?
much of.
Oh, you are appearing in this matter?
Lordship, double AG is appearing, Lordship, double AG.
Acha. Must be a serious matter.
He just called me to apprise the court, he's on way. There's a jam.
Which one? Which one?
One, Lord. By the time I could come, Lord, I wasn't serious.
Very well. 54 কেউ আছে কিনা দেখো? নেই, তাহলে 51 টা দেখো যদি other
Mine,
side.
my lord. 54 is.
হ্যাঁ তো 54 অবধি হলো, 54 passed over. 51 is your other side here.
Oh, Lord. Counsel for the state is not here today. 52.
52.
Yes.
52 করে দাও।
Lord, case is under NDPS Act. Lord, the implication of the present petitioner is allegedly from a co-accused statement. Now, my lord, before I make
No
any-
recovery?
Nothing. My lord, the person who has allegedly taken my name, my lord, he has been granted bail under circumstances which is, my lord, in the record. My lord, may kindly see the order once of this honorable court, page 15. No, sorry, my lord, page 20, sorry. But the second paragraph,
So it's Matiar Rahman took your name.
yes, he is my brother.
Oh. Anyway, sir, if there was no recovery, co-accused.
Lordship, this petitioner fled away from the spot, but Lordship, this petitioner is criminally antecedent, Lordship.
NDPS case?
Yes, Lordship, NDPS case.
My lord, may see-
Conviction.
No, Lordship, charge is submitted and trial is running, Lordship.
He's on bail in that case.
Yes.
In that case, he's on bail. Otherwise, how could he have committed this offense?
Yes.
Yes,
Lord, the offense is not at all committed, my lord, because the person allegedly who was apprehended, my lord, it has been revealed from the CCTV footage that he was taken from his house. And on that score, my lord, the coordinate bench is granted bail.
What was seized?
Uh,
Seizure list.
Gaja,
How much?
46 kg.
From
two
whom?
motor-
Seizure list
From
mentions
two
who?
motorbike, 2 person, they were arrested and this person and another were fled away from the spot.
The petitioner says that there was no recovery of narcotics from him. Stop. He has been implicated solely on the basis of statement made by a co-accused person. Stop. The accused person who took the petitioner's name has been granted bail by this court by an order dated February 20, 2025 in CRM NDPS 67 of 2025. Stop. Charge sheet.
Not yet, sir.
Not pending.
Stop. He will fully cooperate with the investigating officer if granted the privilege of anticipatory bail. Paragraph. Learned State Counsel, while opposing the prayer, says that this petitioner has criminal antecedents. Stop. He is involved in another NDPS case. Stop. However, it appears that he is on bail in that case. Stop. However, Learned Counsel fairly admits that there was no recovery from this petitioner, as according to him, this petitioner fled from the spot where recovery was made, where seizure was made for him. Stop. Paragraph. I have considered the facts and circumstances of the case. Stop. The person, the co-accused person, on the basis of whose statement the petitioner has been implicated, has been enlarged on bail by this court, by a division bench of this court. Stop. There was admittedly no recovery from this petitioner. Stop. Hence, I am of the view that this petitioner has been able to overcome the restrictions in section 37 of the NDPS Act. And I am inclined to allow his prayer so long as he cooperates he is prepared to cooperate with the investigating officer. Correct?
Great. But I'm for the petitioner.
State. Pass over.
55.
Lord, I beg. But order was passed on 13th of October 2024. But condition is that, my lord, the petitioner shall be released on bail upon furnishing a bond of rupees 10,000 each with two sureties of like amount, one of whom must be local. But difficulty is there, my lord. This petitioner is a very poor person, my lord. They failed to furnish the local surety, my lord. Kindly relax on that part, my lord. Instead of local, but registered surety, my lord.
So you have not been able to take advantage of this order till now?
Till date, my lord, I am not.
Yes, sir.
So order passed lordship 13/11/2024 lordship.
Yes,
Page
that we
number, my
see.
lord, 12 to.
So why this delay in
And actually, they are, my lord, trying to, my lord, avail the, my lord, the local surety, but they could not, my lord.
what are the charges?
But 498, my lord. They are the, my lord, in-laws.
No.
No. 498, 85, দেখো না। ভালো করে দেখো। 109 হয়। হ্যাঁ, what a bill দিয়েছে। They in-laws, husband number. They are not.
But 302?
No, 109. 109 or 307 or
307.
307.
Charge sheet filed?
Charge sheet
Much?
not filed. Charge sheet not. Charge sheet not. 85, 498, 109, 307, 35 of 34.
No, if charge sheet is not filed,
Yes.
then you'll be entitled to, if you're arrested, statutory bail.
No, but this is anticipatory bail.
No, but even if you're arrested, if you go and surrender, if charge sheet is not filed, 90 days.
We are getting the anticipatory bail.
Issue. By an order dated November 13, 2024, the petitioners were granted anticipatory bail, inter alia on the condition that they will furnish bonds of rupees 10,000 each with two sureties of like amount each, one of whom must be local. Stop. The petitioners say that they have tried very hard but have not been able to find local surety. Stop. One of the reasons for this is that they are financially extremely weak. They are financially extremely weak. Stop. They pray for relaxation of the conditions of bail by permitting them to furnish registered surety instead of local surety. Paragraph. Learned State Counsel, comma, in his usual fairness, comma, leaves the matter to the discretion of the court. Paragraph. I have considered the facts and circumstances of the case. Stop. The petitioners have not been able to take advantage of the order granting anticipatory bail for more than 4 months, as they say that they have not been able to find local surety. Paragraph. For the ends of justice and taking a lenient view, comma, I allow the petitioner's prayer, petition states it for apostrophe, and permit them to furnish registered surety instead of local surety as a condition of anticipatory bail. Stop. The other conditions mentioned in the order dated November 13, 2024 remain unaltered. Granted, disposed of. একটা করে দাও খালি। The petitioners must comply with the conditions within 4 weeks from date.
I am appearing on behalf of the petitioner, your lordship. This is for relaxation of condition, your lordship. In this matter, the wife of the present petitioner, there was a
So, you're appealing?
No, Lordship, they had filed actually online, Lordship. So online copy, I don't have not received the online copy.
Give him a copy.
yes, your lordship.
Come back tomorrow.
I'll come back tomorrow.
Relaxation. What condition? Indicate.
The wife of the petitioner had to be transferred to Kolkata, admitted in the hospital, your lordship, because she is a patient of a renal transplant, your lordship, and she got developed some infection. So he could not comply with the condition that he would meet the IO on every week, your lordship. That was the condition while granting bail. Earlier occasion, he had complied with that, but subsequent to that,
So,
he
Mr. Looks
failed.
you just
I just need the status report regarding whether charge sheet has been filed or not.
also whether he has been complying with the conditions
Yes,
of anticipatory bail.
That I have annexed in my petition, your
Let
lordship.
him find out independently.
Yes.
When? Day after tomorrow? When?
Tomorrow. You can
Tomorrow.
Lordship, because I just
Tomorrow.
phone call.
Give him a copy, not today.
59. For password.
Moment of arbitrator. Other side is here.
Section 11. Section 11.
So regarding return,
Oh, yes, partnership firm.
I'm sorry, I could not come on some throat problem.
Throat.
Yes, some congestion, Calcutta.
Pollution.
My lord, so yes, and
Yes, you want to
Delhi-
represent yourself. You want to appear in person, sir.
Full mark. 59 না। It is 60. It is 60.
Passed over. 59 is passed in. 60, who is your other side?
Sudipto Mojumdar, my lord, talk with me. There is some.
Then pass it over. We'll take it up in the second call. We'll run through the list. Hey, I'll just rise for 2 minutes.
Yes, ma'am.
Normally in Calcutta at 12 o'clock, we rise for walking, blood circulation.
It was introduced by Justice Dotto and Justice Banerjee.
Shonji Banerjee.
Yes.
Yes. ছিল কি ছিল না? এই তোমাদের গতবার বলেছি না, নোট থাকলে কেউ না থাকলে কিছু নেই। Each. কি হলো?
11 Lordship, I am for the status.
কি হলো? সপ্তম বার্তা কি? তুই ওনাকে বলে রাখ, ও একটা নোট করবে গেছে। তাকে তো বললাম। Yes.
Item number 11, my lord, state may be directed to serve the copy because our notice is yet to be served.
Lordship, that usual order may be passed.
What is the charge?
Charges under
376.
376.
Learned advocate for the petitioner says that service has not yet been effected on the de facto complaint oblique victim. Paragraph, let the state effect service kori ager order jeta dilam. I shall mention this and that ja chilo. Same. When should we keep it?
Malbazar
Thank you,
PS,
Lordship.
Monday.
Monday.
Monday what tarikh?
Monday.
Lord, I am for the petitioner.
I am for the defective.
Lord,
State.
case arising out from marriage.
State.
Lordship, I am this.
Lord, case arises out of marital dispute. Lord, petitioner before your lordship is the
But no
sister-in-law of the victim lady.
Well, no
Lord,
CD.
now,
Huh?
No CD.
Act second.
No CD.
So Lord, now the lady is residing with her husband and in-laws. Lord, mutually, my lord, they have amicably settled the issue. That is my instruction.
I am for the defective complaint, she is there.
So that is correct. What is?
Last 3 months there.
Then, Mr. Vishar, why should we keep it pending?
My lord, because I am in dark because I don't have the CD, my lord.
De facto is saying. Yes.
Defective is personal.
If my lord considers it's a different thing, then
Issue.
I cannot make and record a submission here.
Lord, in 19, I am for
19 state.
19.
It is not there.
Oh, Lordship, it is not there. Superchief Mishra is the Lordship. I think you can get report number 2.
Not today, then what to do?
Not today, Lordship.
24. 25.
My lord, for item number 25, I'm praying for not to do.
Not today.
29.
29. I am for the state. 29.
My lord, actually, this is a matrimonial dispute. The marriage took place 11 years ago, my lord. After lapse of 11 years, the wife realized she was subjected to torture for more dowry. Actually, the date of marriage is 27/11/2024.
You are the husband.
I am the husband, my lord. And charge sheet has been filed, my lord.
Lordship, the injury report shows that age of injury fresh and nature of injury simple, Lordship, and 161 is recorded. Prayer of WPA has been given by the IO and charge sheet submitted on 31st/8/24. So he's been absconding. Absconding charge sheet is there.
What do you want?
Lordship, I've told the whole system, the Lordship can pass necessary orders.
He'll surrender
Yes.
and cooperate.
With the investigation, my lord. Investigation or trial, investigation part of
Charge
investigation.
sheet has been filed.
Charge sheet has been filed.
Issue. The petitioner is the husband of the victim lady. Stop. He says that the entire matter arises out of a marital disharmony. Stop. He and the victim lady are married for the last 11 years. Stop. This false complaint regarding torture for dowry has been lodged only to pressurize him. Stop. There has been usual marital quarrel between the couple. Stop, comma, nothing more. Paragraph. Learned state advocate shows me the injury report. Stop. The injury has been described as simple to within inverted comma. Stop. I have also seen the statements of witnesses recorded under section 161 CRPC. Stop. There are omnibus allegations against the petitioner. Paragraph. I find that charge sheet has been submitted upon completion of investigation. Stop. On an overall assessment of the material on record and the nature and gravity of the alleged offense, I am of the view that immediate custodial detention of the petitioner may not be necessary so long as he is prepared to cooperate with further investigation, comma, if any. Paragraph. Usual conditions.
Grateful.
Thirty-one.
No city order.
No city, not today.
Four.
34.
Yes.
ছিল কি আগের বার? Not today.
38.
For the state, I'm ready with the city.
In the first call also, they were not here.
Who is there? Sudeep Guho.
Is he here? Have you seen him? Sudeep? Or shall I pass it over or? You
Not
get-
today, my lord.
Not today. Not today.
39.
Not today.
I'm for the statement.
Shishendu Kumar.
Shishendu Kumar Roy, Bashunia. Calcutta High,
Have you seen him in court?
principal bench. A member of.
Member of?
Principal bench. Nah, Calcutta High Court Circuit Bench, Jalpaiguri.
He was not there in the first call also.
Yes, ma'am. The first time he was absent.
What should I do?
Not today.
But from tomorrow in the second call, I am going to dismiss. If
Yes.
both the calls, nobody is present.
Yes. State is always.
Not today.
51.
Rita Agarwal, Ria Agarwal.
51.
My lord, counsel for the state, Mr. Shortkar informed me his personal inability today, so let it be tomorrow.
Not today.
54.
For my lord, I am for the petitioner.
E. 55.
Including 55, I beg to appear for the petitioner, my lord.
I am for the defective.
Yes.
What is Mr.
55, 55.
Yes, my lord.
Court number 4.
55 de facto. Oh, I see. He was here the last occasion, no? Then not today, what else?
Not only. Yes. 59. Yes.
This is an application under section 11 of the my lord Arbitration Act.
Can you agree on the personnel of an arbitrator? Can you agree on a name?
No, we did not agree. They did not agree. We had sent them a notice under section 21, which they did not reply to.
Now can you agree? If you suggest a name,
My lord, anybody from the panel of arbitrators in this circuit bench?
where is that panel?
Lord, generally, Mr. Arnav Shah and Mr. Neela Chakraborty is generally appointed. Both these, in my matters, my lord, I have found them to be appointed.
So I can appoint anybody from here. What is the stake? How high is the stake?
My lord, partnership firm, settlement of accounts, and my lord, distribution of assets. That is what is.
My lord, আপনার 2010 সালের মধ্যে দুই ভাই মিলে আমরা এটা আপনার দুই পার্টনারশিপ মিলে এটাকে বন্ধ করে দিতাম। তারপর 2012 সালে আমাদের এটা হলো যে ইয়ে থেকে একটা একটা হলো যে ব্যাংকের থেকে অ্যাডভোকেট থেকে একটা ইয়ে আছে ব্যাংকের লোন ছিল, লোনের একটা ইয়ে ছিল, লোনটা শোধ করা ছিল। তখন আমরা সেটা দুজন মিলে অ্যাকাউন্টটা সেটেলমেন্ট করেছে, সেটেলমেন্ট করে ব্যাংকটা ইয়ে লোনটা শোধ করেছে। আর তারপর 2013 সালে
The partnership has been dissolved.
হ্যাঁ কমার্শিয়াল একটা
We have, my lord,
Just
sent
defunct.
them a notice for retirement and hence dissolved. But after that, my lord, the settlement of accounts and the distribution of assets are pending.
হিসেব পত্র তো ফাইনাল করতে হবে, তার জন্য একজন আরবিট্রেটরের দরকার। সেটা অ্যাপয়েন্ট করে দিচ্ছি কাউকে, হ্যাঁ, দুজনে মিলে বসে দুপক্ষ বসে তার সামনে, হ্যাঁ। Now the name, I'll pass the order in chamber. এটা চেম্বারে অর্ডার দেব।
স্যার অ্যাকচুয়ালি কিন্তু অ্যাকাউন্টটা করা আছে, অ্যাকাউন্ট করার পরে কিন্তু আমরা ব্যাংকে যে লোনটা ছিল না সেটা ফাইনাল করে আমরা দুই ভাই মিলে অর্ধেক অর্ধেক দিয়েছি।
সেটা arbitration.
Is there a real dispute between
Yes,
the brothers?
there is. Because of the distribution of assets, my lord, is in fact pending.
তারপর স্যার ভ্যাট নাম্বার ছিল 2013 সালে একটা ভ্যাটের থেকে একটা মেল
Have you indicated the disputes in your
No, my lord.
petition?
No, my lord. The disputes are, my lord, indicated in the notices.
In the notices?
In the notices.
Where's the notice?
My lord, the notice, my lord, will find from pages 19 to 26. my lord.
19 to 26. Very well. এটাকে পাঠিয়ে দাও চেম্বারে। এটার order record করো। Hearing is concluded. Stop. List this matter under the heading for orders. পরশু দিনের ডেট দিয়ে দাও। আর আছে কিছু?
I've got dispute regarding determination of the tenancy right or shoot premises.
So this has been hard for long. This is not a tenancy right to be decided. The tenant was a partnership firm where in the partnership deed there was an arbitration. It is not tenancy will be decided by arbitration.
Yes, anyway, yes, well, I am not disputed, can you?
We are on agreement that let there be arbitrator be appointed. So Mr. Roy was very generous enough to ask me to suggest the name. So if
You
it
also
is-
can decide.
Your my lord can give.
You
a
know
name
the
or we
civil.
give-
No, why don't you agree? That makes life easier for me.
My lord,
My lord.
we leave it on the my lord.
As a senior member, I have some problem.
Why don't you then give me write out a cheat? Give it to me. You don't have to.
Please, please. It is not.
I don't know many people here. It
It
should be a local person, na?
Yes, madam, that is what I want.
Yes.
Our prayer is that.
Therefore, you should help me because I do not know everybody here.
But then if your lordship is that way, I am suggesting Mr. Saurav Ganguly advocate.
Yes.
If he doesn't have any objection.
I don't know.
Oh, Mr. Saurav Ganguly.
Mr. Ganguly.
So he should be acquainted with the civil law.
That he is. Where's the arbitration clause?
That is 51. Sorry.
No, lordship is trying to find out the partnership. My lord, lordship will find it. 17. Page 25, my lord. Clause 19.
Well, I just, Mother.
These parties to this petition are all partners of the firm.
No,
only-
not one. I just said,
Petitioner number,
I just, I felt shoot for declaration of tenancy right. One is my lord landlord. There are 2 and 3 are my nephews. My case is that.
Petitioner is who? Petitioner is the.
uncle of petition and respondent number 2 and 3.
Just a minute. I say that there's a partnership deed.
Petitioner is the landlord.
No.
OP number 1 is the landlord.
I see.
My case is that there's a partnership deed. It was dissolved. I was only the land tenant against the dividend 1. They say there's a partnership clause. I can't say what section 8 allowed here, the High Court. So arbitration clause is there.
You are for 2 and 3.
Lordship.
Yes.
Who is for 1?
Lordship, I am also representing 1.
You're also representing 1. I see.
So, I filed a shoot for declaration of my tenancy right. This I annexed it, but they say it's a partnership deed. So, partnership.
You are all related.
Yes, sir. Nephew. My nephews.
Petitioner and opposite number 2 and 3 are
My nephews.
related in a very bitter way.
Bitter way.
Always.
So they say that the partnership firm was a
Tenant.
That was dissolved.
You say so.
Yes.
They
say
say
it was
no.
dissolved.
I am the
only
sole tenant.
Sole tenant. This is the dispute.
Yes.
So the
Yes,
partnership clause says that any dispute relating to the tenancy, right of tenancy will be.
I'm not going to that. Section 8 was allowed the High Court, so I can't.
That has been settled now by the Honorable Court.
Otherwise, I'll say, I can't say now.
Very well. Then Esho. Mr. Ganguly, please do everybody a favor by acting as arbitrator. This is an application for, this is an application under section 11, bracket 5 or 6 of the Arbitration and Conciliation Act, 1996, for appointment of arbitrator for resolution of disputes that have arisen between the parties. Here too, stop, paragraph. The you are OP number 1 is not a was not a partner.
No, he's the land.
He's the landlord.
The petitioner and the opposite party numbers 2 and 3 were partners of a partnership firm by the name of
New Priya Medical.
New Priya Medicals. Stop. Firm stands dissolved.
Yes. My lord, that is.
But he was not the partner. He
Right.
was not the partner.
Stop.
He was not the partner.
The
But sorry, he was not the partner. This is a.
3 not a partner, only
was the
2. Only 2. The petitioner and the respondent number, OP number 2
Yes.
are partners.
আমি ভুল ডিট জানা করেছে গৌরচন্দ্র ঘোষ মারা গেছে
তারপরে এসেছে তিন আছে
তারপর রিকনস্টিটিউশন
হ্যাঁ
The petitioner says that he is the tenant under the OP number 1, the landlord. Stop. The OP,
under the mother of the opinion one. My mother was the original landlady.
OP number 1 and his mother, since deceased.
Yes, ma'am.
Stop. The OP numbers 2 and 3 say that the partnership firm is the tenant under the landlord. Stop. In short, this is the dispute which requires to be resolved. Paragraph. The partnership deed contains an arbitration clause which reads as follows. Page 25, 26 এ আছে, clause 19 টা set out করে দেবে। Paragraph. Both parties want to go to arbitration. Stop. All I need to do is to decide on the personnel of the arbitrator. Paragraph. In my considered opinion, Mr. Saurabh Ganguly, ex-captain India, no, ওটা লিখো না, ওটা লিখো না। Mr. Saurabh Ganguly, learned advocate, will be a fit person to arbitrate the disputes between the parties.
To once again lead us.
Stop. I appoint him as the arbitrator. Fees and all you will fix up. The arbitrator shall be. Now these days there is a schedule of something. Yes, the provisions of the provision of the Arbitration Act will. Arbitration Act 96. 96. Arbitration and Conciliation Act 96 will govern the arbitration as well as the issues pertaining to the remuneration, etc. of the learned arbitrator. Huh? That is all.
Yes,
Lordship, only one need, if it is written New Priya Medical, it will only Messrs Priya Medical.
New Priya, no? It is Messrs Priya Medicals.
no new.
No new.
Very old business.
Huh?
Truly old business.
Paragraph, since no affidavits were called for, the allegations made in the petition are deemed not to be admitted by the opposite parties. Next, AP such and such is disposed of.
Yes.
Lordship, before my lord rises, I have a submission different, let's say, my lord. My lord, right now I received a call. I've been called to appear before the Honorable Chief Justice Sikkim High Court tomorrow in a public interest litigation. So with your lordship leave, I must leave for Sikkim. There are certain matters fixed before your my lord in the petition
course.
bench. You
Tomorrow
always,
I'll oppose. No, no,
In the second half,
no, no.
Yes, my lord.
today in the second half.
I will be leaving after.
Yes, yes, you take us with you.
Please, my lord.
I also will be both of us, my lord.
No, my lord, it pertains to an instant.
Ask your juniors to indicate. We always accommodate Mr. Mojumdar. But provided your other side doesn't create
My lord,
difficulty.
if my other side objects, he will never go to Gangtok because it is NH10 that is the in dispute.
No, no, I
You will come back today itself, no,
No, my lord, I
tomorrow.
will come back and tomorrow evening, Friday, I will be here all day. Any matters that will be established.
Very good.
Grateful, my lord.
You're going back today, no?
No,
my lord,
Yes,
your lordships, my lord, may I mention, my lord, item numbers 86 and 87 of today's list? We have been trying in vain for the last 5 circuit to have the matter heard because of the intransigency of the state government to have their appeal heard as well as our appeal to be disposed of. But we have tried to serve notices only yesterday. We failed. Today we sent by notices by email as also physically in the department. None of them, I do not know whether anyone is appearing or not. My juniors are there. They have gone from Calcutta. I was also supposed to assist your lordship physically, but I am unable because the state government is, it's not the state government, it is the respondent number 7, which is avoiding their own appeal, which was, and this appeal against
what
them.
do you want, Mr. Kundu? Let us proceed. What do you want?
Lord, may the matter be taken up despite the intransigency of the state government to at least hear the matter, at least my appeal be disposed of, my lord.
Let us see, let us proceed, let us proceed, let us see.
My lord,
We are
only
not
one thing, my
granting
lord,
upgradation to anybody, Mr. Kundu. Let us proceed.
I know, but the problem is, my lord, I have been, my lord,
Let us see, we might be able to call it. If they are not present, we'll hear you. Allow us to proceed? Yes, call the list.
In item number 1, I'm praying for 1 day's accommodation.
Not today.
Item number 2 is short pass over lordship. Senior appear in port number 2, lordship.
Chalo, next.
I am for the Commissioner, learned Deputy Solicitor General yesterday took time.
Yes, but the DSG said that he will not be available today after recess. He has to go to Sikkim, Gangtok to argue.
Yesterday he took time.
This was an emergency. He did not know yesterday. He requested us to keep matters on Friday, not today and tomorrow.
My lord, Friday.
Friday.
Lord, kindly ensure that it retains the position.
Yes, this will be at the top of the list as it is.
Diplomacy.
Lordship, I am little bit delayed. My matter was item number 2. Passover. Next, Passover. Number 4.
Petitioner?
Passover.
Chalo, next, Dako.
Number 5. I'm for the appellants in item number 5, lordship.
I'm for the state.
There are 2 appellants, lordship. However, appeal was admitted, lordship. One of them, namely Regina Bibi, has prayed for this bail application, lordship.
No, this application is made by 2 accused persons or only Regina Baby?
Regina Bibi for suspension of sentence, lordship.
Only one has filed?
Only one has filed, lordship. Conviction that was awarded to this appellant is life imprisonment, lordship, on the basis of the statement of a minor witness, lordship. Kindly come to firstly, lordship, this
Yes.
firstly, lordship, this appellant was all along the bail except 120 days while she was in trial, lordship. Kindly come to page number 22 of my PRAN application, lordship. This is the.
She was all along in on bail, accepting
122 days in custody.
During trial.
during the trial.
At
Lordship.
the initial stage.
At initial stage, Lordship. Kindly come to page number 22 of my CRAN application, Lordship.
Well, let us hear him. We have gone through the papers, that is why. We have gone through the
Lordship. And
Yes.
subsequently, I received 164
there
statement,
are
Lordship.
prima facie, there are holes, gaps in the evidence of PW2, the eyewitness,
Right,
and
Madam, the minor.
PW4. Yes. Now, false implication cannot be ruled out because of land dispute. A baby, 11-year-old, no, for the child,
7-year-old.
12-year-old child being put on fire, nobody hears anything, no cry, nothing at all. 6 years in
She has
custody,
taken the
no.
key from her brother to enter the room.
And FIR lodged after 8 days from the date of
Lordship.
incident.
All along on bail, convict her if you can. I mean, she has been convicted, but off the record, there's a fair chance of her.
My lord,
That's
he has
too
a good case for trial. I mean,
So much contradictions are there, my lord. So,
Isho. See, we have done our homework.
Lordship. So it's easy.
This is an application for suspension of sentence in an appeal filed by, she was accused number 2,
Lordship.
by the accused number 2 against the judgment and order dated November 29, 2024, passed by the additional district and sessions judge, fast track court, Kuch Bihar, in sessions case number 39/2019, whereby the petitioner and the other accused person were sentenced to suffer rigorous imprisonment for life and were also fined for commission of offence punishable under section 302/34 IPC. Stop. Paragraph. The appeal has been admitted.
Lordship.
Paper books ready, you know.
No, Lordship.
Stop. The payment of fine has been stayed.
Lordship.
Stop. Now the petitioner prays for an order to release her on bail pending disposal of the appeal. Stop. Paragraph. We have gone through the evidence on record. Stop. Prima facie, there appears to be gaps and holes in the evidence in the deposition of PW2 being the sole eyewitness, said to be the sole eyewitness. Stop. There is inconsistency between the depositions of PW2 and PW4. Stop. The possibility of false implication by reason of land dispute between the parties cannot be ruled out. Stop. The petitioner was on bail all throughout, excepting for the initial 122 days after she was arrested in connection with the case. Stop. Paragraph. Apart from the aforesaid, the appeal is still not ready for hearing. Stop. Appeals which are several years old are pending. Stop. There is not much likelihood of the appeal being heard on an early date. Appeal being heard and disposed of on an early date. Paragraph. In view of the aforesaid, comma, we are inclined to allow the petitioner's prayer for bail. Pure usual যে order থাকে যেমন এমনি bail order, না?
My lord, my lord, one indulgence. As she is from the same locality, she should not be in that locality, within that police station. She should still the hearing.
Actually, he had no question of examination of witnesses.
Even then, it creates.
No, no question of influencing witness any further. Everything is on record.
Even then.
That means she will be within the jurisdiction of this district. She will remain, reside within the
But he will
jurisdiction.
not enter the jurisdiction of this police station, but because they are neighbors. So that's-
Which police station? Which police?
Where the incident took place. That means she will not enter into that locality.
Locally.
Where
But
the incident took place.
of occurrence.
For the time being, until further order. The petitioner shall not enter. Tell us which PAS. The key locality, but যেটা বলুক কি?
That village or that.
Yes, Kotwali PS Kuchbihar.
Kotwali Sodor.
Sodor PS, Kotwali PS Kuchbihar.
Why confine her? Tell the village. She will not enter the village.
Which village?
That means that place of occurrence. That village she will not enter.
My lord. আঠারো
বোঝা যাচ্ছে না বোঝা
আচ্ছা ওর অ্যাড্রেস তো আছে বড় 18 খা বড় BORO ATHAROKOTHA ভিলেজ না না এটা
বড় 18 কোঠা
বড় 18 কোটি।
This is the cost বড় 18
বড় 18 কোটি।
বড় 18
কোঠা
She will not enter into that locality.
Until further order.
Get to. I can take.
Lordship, that matter was regarding that limitation of in 378 CRPC.
Who was appearing in the other side?
My lord, this is appeal, admission of appeal stage.
Oh, admission.
CRM SPL.
Yes, yes.
You will learn that DSG will appear in this case, my lord. And I have the judgment of Honorable Apex Court.
No, DSG requested us not to take
Yes,
up matters
yes.
today, Friday.
If your lordship allows me, then I can give the judgment.
I shall give the judgment. ছোট্ট order করে নাও। Copies of the judgment on which the appellant wishes to rely, comma, have been filed in court, stop, let the same be kept with the records. Paragraph, on the request made on behalf of learned Deputy Solicitor General, comma, let this matter stand adjourned and be listed again on Friday date. আর এই ফাইলটা পাঠিয়ে দিও তো এখন দেখে নেবো কি জাজমেন্ট কি বলছে ফাইলটা পাঠিয়ে দিও
paying for adjournment loss. Kindly fix the matter Friday loss.
Friday.
Yes, loss.
Friday. এই রেকর্ড করো record for on the prayer made on behalf of the appellant, comma, let this matter stand adjourned and be listed again on Friday date. Yeah.
Item 10.
For the appellant, my lord.
Why?
Lordship, in this matter, Lordship, we need some further instruction for current status. This matter relating to contract, your Lordship, contract terminated. Then your Lordship, this matter will arises. Earlier operation, your Lordship had earlier.
This matter was heard by your lordship last time.
Last operation.
That we don't remember. That we don't remember. Very well. On the prayer made on behalf of the Union of India. Comma, let this matter stand adjourned and be listed again on सामने बुधवार date दिया.
Yes.
Your Lordship, I'm for the appellant. Your Lordship, I'm praying for 1 day adjournment, Your Lordship.
For the state.
Why?
Your Lordship,
If you're not
advocate on record
interested
is-
to do the matters, why should
He will
we?
be appearing tomorrow physically, Your Lordship.
Who?
At the advocate on record, Your Lordship.
On the prayer made on behalf of the appellant, let this matter stand adjourned for the day.
Your Lordship, I'm for the, I'm for the appellant. Your Lordship, item 12. Your Lordship, I'm praying for not this week, Your Lordship. This showing defective over here, that's need to be ascertained and some instruction are still yet to be taken.
That's it. I'm appearing for the postal department.
Huh?
Postal department.
The learned advocate for the petitioner prays for some time to find out what the defect in this appeal is and to remove the same. Paragraph as requested, comma, let this matter be listed again on Monday, date the other.
Grateful, Your Lordship.
Dada. 10 আর 12
Item 13. Lordship, I beg to appear virtually in item 13.
Canody is appearing virtually. Lordship.
I beg to appear virtually, Lordship. Lordship, this is a GST matter. I am aggrieved by the judgment passed by the learned single judge Lordships regarding rejection of my refund. Lordship, the issue, there are two issues in
Sir,
this.
the appeal has to be heard out.
Lordship, yes, it is not yet admitted.
No
But
interim
Lordship,
order.
I'm just, Lordship, just praying because the learned single judge had this. There were two questions, Lordship. One was a question of law and one because in GST there is no tribunal. It had to be decided on merits. The learned single judge, Lordship, had decided the question of law against me, but has not decided the merits at all. So if you're, but Lordship, I am aggrieved by the decision of the learned single judge to the extent of the law point which has been decided against me.
This is 2nd of August.
Lordship, 2nd of August. Lordship, may kindly have para 14 of that judgment.
We are not deciding anything now today. So let us direct preparation of paper books. Appeal will be heard out.
So it's a matter of refund. Some short date will be given to the opposite side for counter. Because I'm suffering non-grant of refund, Lordships.
Who prepares the paper book? The appellant or the department? Appellant.
Lordship, in this case, it's an intra-court appeal, MAT.
You prepare informal paper book.
Lordships, I will prepare.
The application, Lordship.
Yes. You still prepare? Huh? Issue. This appeal is directed against a judgment and order dated August 2, 2024, passed by a learned judge of this court in WPA 1905/2023. Stop. The appellant's writ petition was dismissed. Stop. Hence this appeal. Paragraph, there is no scope for passing any interim order. Stop. The appellant's claim for refund
Lordship, refund.
on account of GST has been rejected by the learned single judge. Paragraph, let the appellant prepare requisite number of informal paper books, incorporating therein all papers that were available before the learned single judge, comma, within a fortnight from date.
Lordships.
Stop. All formalities are dispensed with. Stop. Since the respondent, you represent all the respondents. Since the respondents are represented, comma, notice of appeal is deemed to have been waived. Stop. Paragraph, list the appeal after 2 weeks before the next available circuit bench.
Much obliged. Grateful to your Lordships.
For the state.
Hey, just 1 second, 1 second. The again matter tab.
Lordships.
You're there, Mr.
I'm there, Lordship. I'm there.
The application can be disposed of.
Lordship, stay application is there, Lordship, but generally in intra-court appeal in tax matters, both are decided together, Lordships. This actually
The appeal along with the connected application, Kurada.
Lordship, may I just
Yes, next.
Grateful to your Lordship. Much obliged.
14, you have got the state, my lord.
I'm paying for non-promotion.
On the prayer made on behalf of the appellant, let this matter stand adjourned for the day.
My lord, I for the
15 Lordship, for the appellant petitioner, I am led by Mr. Dipanjan Datta. He is on the virtual.
May I have your lordship's leave to appear virtually, my lord? My lord, may I have your lordship's leave to appear virtually?
Well, we are not happy about it, but we'll allow you. Hey, volume টাকে বাড়ানো যায়?
My lord, the appeal has to be
Can you increase the volume?
My lord, my system shows that the volume is at its maximum.
Here also it's maximum, but that's not sufficient. Why is the weather is beautiful? Why don't you come? Excellent weather.
My lord, the appeal arises out of an order by which the learned single judge had directed the the rejection of the order for termination of the employee of the bank, thereby directing him to rejoin his services. My lord, if your lordships are pleased to admit the appeal, my lord, I would pray for an interim protection so that my learned friends may not proceed with any proceeding under contempt.
My lord, I am for the respondent. My lord, I am suffering since 2020 on November. The solemn order passed on 7th of October 2024 by the Honorable Single Judge. Now, my lord, at the outset, I can only say
that all relevant points were considered and adjudicated by the learned single judge. Also, the fact states that we have preferred a contempt applications only after a liberty was granted by the Honorable Division Bench on the last occasion. On the very fact that an accommodation was sought by the my learned adversary, and on that ground, a liberty was granted.
What is the charge?
The charge is of several irregularities and primarily, my lord, of unauthorized absence for a continuous period, my lord, where he has indicated that he was initially being treated at a hospital, and he indicated by his through his wife's email that he would be discharged on a particular day. Even thereafter, he did not join. Thereafter, the unauthorized absent continued for more than 6 months.
Yeah. Mr. Dotto, instead of admitting it and then considering the question of stay, let us hear out the appeal, dispose of the appeal.
My lord, I am ready with the appeal.
Come back next week.
My lord.
On Monday, come back on Monday, both prepared to hear out, to argue out the appeal. All papers are before us?
Yes, yes, yes.
All papers are before us.
Only thing is that
Come back on Monday at 3:30.
3:30, my lord.
Grateful, my lord.
This appeal is directed against a judgment and order dated October 7, 2024, whereby a learned judge of this court set aside the order of removal from service of the petitioner, including the memorandum, the articles of charge, the findings of the inquiry authority, the order of the executive director and appellate authority capital, dated May 3, 2023, and all subsequent proceedings in connection with the concerned disciplinary proceedings. The learned judge further directed that the petitioner shall be allowed to resume service forthwith with full back wages. Being aggrieved, the employer bank is before us by way of this appeal. Paragraph. We are told that all papers that were there before the learned single judge have been annexed to the stay petition.
Yes.
We propose to hear out the appeal itself, treating the stay petition as an informal paper book. Paragraph. Let this matter be listed on Monday date the marked 3:30 p.m. We request learned counsel for the parties to be brief in their oral submissions and to file written notes of argument.
My lord, I shall. My lord, I shall.
Try to conclude on that day.
Lord, I would seek your lordship's indulgence to allow me to appear virtually on Monday also.
Mr. Dotto, problem is there might be a technical hitch, as it is the volume is not adequate.
I will try my best to adequately assist your lordship to the best of my abilities.
Do your best.
Grateful. my lord.
Since your lordship is intending to hear out the appeal, I'm not asking for any formal order of stay. It would be an understanding that they would not proceed.
Don't do anything till next Monday.
Already 6 weeks times have been given by the.
But then I'll have to pass a formal stay order.
No, that's the request.
Yes, all right.
My lord. My lord.
Hey.
Grateful, my lord.
Much obliged.
My lord, 16, my lord, I appear for the appellant, my lord.
Yes.
My lord, I appear for the appellant, my lord. My lord, this is an appeal against an order dated
Mr.
27th
Ghosh, you
of
appear for the
Oil company respondent.
Your lordship comes to the impugned order at page 31, annexure A to the stay application dated 27th of November 2024. Now, I'm allowed,
your writ petition has been dismissed.
it was dismissed on the ground that there is an alternative remedy in the form of an arbitration proceedings. My case was very simple, that I was not a licensed distributor of the IOC at a point of time when there was an May I proceed, my lord?
Yes, it will take a little time, Mr. Kundu. This matter will take a little time. So come back next
All
week.
all the papers there.
Correct. We are not directing paper book. We'll treat this as a paper book and we'll hear out the appeal.
In that event, my lord, lordship will fill it out any days next week, if your lordship.
Yes, next Tuesday.
Next Tuesday. A particular time, if your lordship so pleases.
Yes,
I'll
next
come up
Tuesday at 3:45.
45. Of course, there is an interim order which was passed by the learned judge at page 48. If your lordship goes through.
Page 40?
48.
Interim order?
Yes, your lordship sees, my lord, there was an interim order which was said later, the later part, after the formal order was passed by the learned single judge, dismissing my appeal. Then his lordship was pleased to, on my prayer.
But that 4 weeks expired long time back.
I'm only saying that. I'm not formally seeing this thing, so I'm only trying to impress upon your lordships that if the matter can be disposed of next week, so that I can at least go either
We have fixed it on Tuesday.
very well. 3:30, and I'll come up with the notes and argument for your lordships.
Notes of argument, both of you. Dekho, order lekho. This appeal is directed against a judgment and order dated November 27, 2024, whereby, the appellant's writ petition being WPA 347 of 2023 was dismissed by a learned single judge of this court, as not maintainable in view of an arbitration clause. Stop. Paragraph. The appeal will have to be heard out. Stop. We are told that all papers that were available before the learned single judge have been annexed to the stay petition. Stop. We shall treat the stay petition as an informal paper book and hear out the appeal on Mongolbare date dao, when this matter will be listed again marked 3:45 p.m. Stop. We request the learned counsel for the parties to be brief in their oral submissions and file written notes of arguments.
Deeply obliged, my lord.
Hero.
Item 17, Lordship, in item number 17, I am for the income tax authority. Lordship, this issue.
Yes.
Lordship.
My lord, I'm leave to be granted to appear online, my lord. I'm appearing online. My lord, am I audible?
Shortcut code.
My lord, am I audible, my lord?
You are, but not adequately.
Yes, my lord, there is.
Lordship, may I permit to short this matter? There was a interim order in the appeal. The issue relating to income tax says 148A(d) challenge. Now, this issue is pending before the Supreme Court. Several High Courts, several order, one Bombay High Court against the Union of Income Tax Authority. Now, subsequently, all the petitions filed by the SLP and this pending. In this appeal, there was a direction for affidavit also for the Income Tax Department. Till yet, I am not filed any affidavits. So, Lordships, kindly extend the time and extend the interim order also.
My lord, in the last order, my lord, in the last.
Issue is pending before the Supreme Court.
My lord, may I please, my lord, in the last order of Justice Tandon, somehow the interim order was removed. My lord, it was first heard on 24th December by Justice Madhuresh Prasad Division Bench, where an interim stay was given. Further, Justice Jaimalya Bagchi Division Bench extended the stay. My lord, on 10th March, in the last date, my lord, somehow Justice Tandon, there was no interim order. My lord, the interim order can be given back so that no coercive action may be taken.
That's all right, we'll do that. Learned advocate for the Union of India, the Income Tax Department.
Yes.
Income Tax Department says that the issue involved in this appeal.
That's it.
IP, interpretation of
148(d) of the Income Tax Act, that is the issuance of notice under section 140 by the JO, Jurisdictional Assessing Officer.
Capital A, capital D.
At
My lord, small d.
Small a, small d.
My lord, 148 capital A, small d. My lord, 148 capital A within bracket small d.
Within bracket small d of the Income Tax Act.
Yes, ma'am.
Comma is pending consideration before the Honorable Supreme Court. Stop. Paragraph 18 that earlier, direction was given by a coordinate bench for exchange of affidavits on the stay application filed by the appellant.
Yes, ma'am.
Stop. We extend the time for the respondents to file affidavit in opposition by 4 weeks from date. Stop. Reply thereto, if any, be filed within 4 weeks thereafter.
Yes.
Paragraph. An interim order had been passed by a coordinate bench on December 24, 2024, restraining the department, capital D, from taking any further action based on the notice dated March 15, 2024, and the notice dated October 17, 2024, issued under section 142(1) of the Income Tax Act, till January 24, 2025. Stop. However, it appears that subsequently, the interim order was not extended, and learned counsel for the parties say that this was due to inadvertence. So we reinstate the interim order that was passed on December 24, 2024, and direct the same to continue 4 weeks.
My lord, it may be given till disposal of the appeal, my lord.
No, Your
No,
Lordship.
till now, because
Your Lordship.
till the end of June, 2025, or until further order, whichever.
Lordship. In this case, in our coordinate bench is a different view. That is also, we have placed if affidavit fine.
Fight it out before the apex
That's
court.
what it is.
Deeply obliged, my lord.
Your Lordship, in item number 18. Your Lordship. Matter, but he is another court.
AAG.
AG. No.
Well, this is my appeal.
No.
My appeal.
Mr. Chaudhary.
Mr. Kishore Datta.
AG.
AG is appearing, so my lord, now
Yes,
he's
come
another.
to Jalpaiguri.
No. He's virtually appearing in this matter, but he's another.
So what you want not today?
Not to them.
On the made on behalf of the state. Let us stand agent for the day. Okay, so.
My lord, we were appearing for the appellant.
Come back tomorrow. Mr.
Well, tomorrow.
Have you lost weight?
That's what everybody says, but technically I haven't lost because my weight is still the same.
You're still a very weighty counsel, that we know, but you look sleeker.
Yes, that's what everybody says, but fortunately, my weight has remained the same.
So when you come back, I'll tell you what.
It into muscle mass. That's what the doctors say.
All right. Thank you. Next matter.
Item 19. I am for the writ petitioners. Petition of the appellant.
I'm praying for some time to file the reply.
Well, say, I'm a writ petitioner. I got the order, they have challenged the. Do they ask you to file?
Direction was given for exchange of affidavit.
Yes.
On their stay application.
Yes. So I have already filed my opposition.
Yes. On the prayer made on behalf of the appellants.
Next.
Of the petitioners, we trying to file affidavit in reply extended by how long you want?
They told me.
Next Monday.
Next Monday.
Are you sure?
Next Monday. Give it next week.
Extended by 2 weeks from date. Extended by 2 weeks from date.
This short reply they have because point of law.
Again, they have to seek time. If they are unable, again they will come and seek time.
My jury, his senior sent me to their filing.
Next available certificate.
His senior told me, so he was my chamber junior, today he will file it. So I this.
Item 20, I'm the petitioner. I'm praying for some time to file the reply.
Your Lordship, in this matter, the opposition is yet to be filed, Your Lordship. So,
Opposition not yet filed.
Not yet filed, Your Lordship.
On the prayer made on behalf of the writ petitioners, how many?
One writ
petitioner oblique respondent. You are respondent in the appeal.
Yes, Your Lordship.
Respondent oblique petitioner. Respondent number 1 oblique. Trying to file affidavit in opposition is extended by 2 weeks from date. 2 weeks? 1 week from date. It will be the stock. Reply thereto, if any, we file within a week thereafter.
Yeah.
Paragraph lists the matter after 2 weeks before the then available certificates.
Lordship, item number 21, I'm praying for not today.
You are 21, Mr. Choli?
No, my lord, I'm 27. So
21 on the prayer, I should have report. on the framework on behalf of the appellant. This matter stand adjourned for the day. Sir, what is the defect? It says defective, QR.
Lordship, I haven't gone.
No, have you seen the list? The list it says defective.
I'm checking.
Check up. Chalo.
My lord, item number 22, I am in the online, my lord. Sought for accommodation for the next week, my lord. I intend to make hearing in physically. So that kindly fix it on Tuesday, my lord.
On the request made by learned advocate for the appellant who appears virtually, who appears today on the virtual board. Let this matter stand adjourned and be listed again on.
For the appellants in this matter, but I basically only want intelligence to fix this matter on any day in the next week. I actually require a copy of the death cum retirement benefit rules. And that copy I don't have.
On the trade made on behalf of the appellant. You are for the state?
State. It's a state.
I am for the repetition.
This matter stand adjourned and be listed again on next Buddha.
Grateful, Lordship.
My lord, I am appearing for the respondent's petitioners, my lord, in this matter. I am opposing, my lord, several dates, my lord, matter is hard. The appellant, my lord, did not appear.
You appear for whom, sir?
Along with the Mr. Konar.
Mr.
Mr. Devbroto Konar.
Koron. My lord, Devbroto Koron, my lord.
Yes.
The appeal is delayed by 106 days, my lord.
We don't worry about that. I'm sure you will not have that. Hey, can one?
It was subsequently filed.
Can tutor niye kore dao? This is an application for condonation or delay of such and such days. What is can one? Can one is the stay.
Can one is. Lookout notice has been issued.
Let us see the impugned order.
Yes. In a 490 to 307 case against the husband, and the husband is already at that time. Husband was in UAE, Dubai, man. He was already outside the country. Now he is stuck there because of this red corner notice. Joint investigation, let me return to my country.
This writ petition is pending.
Yes. Yes, Lordship.
Richard.
498.
Mr. Vishwas, we are not inclined to touch the portion of the order which directs handing over of the Stridon to your wife.
That part has been complied with, my lord.
Already
We have-
complied with?
Complied. That has been
Oh.
complied. We have no headache about that, my lord.
I see.
My issue is that now I am stuck there in Dubai. I cannot come to India. I cannot exercise my rights of anticipatory bail, other rights because of this notice. Usually what happens, my lord? The lookout notice is issued in the cases where there is a flight risk. But I was already
Lookout
there.
notice has been issued,
You issued, my lord. They have complied it and it has been issued now. Now I am stuck there. I cannot even if I have intention, I cannot join the investigation.
What if we stay the operation for 4 weeks so that he can come back?
Lordship, prior to entering into the merits of the appeal, I challenge the maintainability of this mandamus application. Lordship, may kindly take up priorly this petitioner. He had preferred MAT 3 of 2025.
Yes, this petitioner or the.
This petitioner. This petitioner.
Yes, there is order 27/1/2025.
No. This petitioner, order dated 27.
Lakshman Chandra, Lakshman
Yes.
Chandra.
Yes, he is the father of the.
What is this
writ
petitioner?
Now,
This petitioner is the son. Actually, what happened, my lord?
Present writ petitioner.
Yes,
present
he's the
appellant.
son. He is the affected one. He is there in Dubai, my lord.
now
The
he has
parents,
filed.
they filed.
Isn't writ petitioner?
Yeah.
No, private
Present
respondent.
appellate, my lord. Present appellate.
Appellant, private respondent.
Private.
Yes. Now,
Parents were not the affected party. That is why that appeal was dismissed and liberty was granted in that order.
now again, this mandamus appeal has been filed by the son who, without any explicit, the father has filed this application without the explicit authority of the son.
Who is Rudraksha Ghosh?
Yes, he is the
son.
son against whom the lookout notice has been issued.
Against him?
Yes,
He is the appellate.
He is the husband.
he is the husband.
Appellant.
So he
Appellant.
is the appellant.
Yes, but the affidavit portion,
The
it is the
can
father
do
who
it.
has
The anticipatory
shown the affidavit
parents are doing it.
without
Yeah,
any
no.
explicit authority.
No, only authority is required when somebody other than the family member is
No,
is from the evidence.
no.
He is in Dubai. He cannot come to India. The father has affirmed the affidavit.
Nothing has been mentioned.
My lord, in anticipatory bails also express authorization is not required.
This is not a bail.
Procedure is
No.
And Vokalatnama is executed
Vokalatnama-
by father.
Yes. Oh, no, by the Rudraksha Ghosh himself.
Vokalatnama executed by.
Rudraksha by post it came from Dubai.
So why
What is the
couldn't?
written authority of the
Yes.
father?
My lord,
There is nowhere.
what is the practice here, my lord?
No, practice will not do, Mr. Vishwas. Whatever the practice is, without an authority, he could execute a wakalatnama and authorize you. And he couldn't execute a letter of authority, at least a letter of authority in favor of his father. We are not going to entertain this.
No such document has been placed.
Esho. On this ground,
We will file a letter of authority, give us 1 day time, we'll send an email, we'll receive an email, we'll file it. This is Dubai. By email, we'll bring it. By email, we'll receive it. Monday.
Collect all the necessary documents.
Mano, we'll bring an email.
They have to appear before the embassy.
exactly.
Then it has to be notarized.
Notarized.
Then it will come to India.
Whatever they have to do, they will take steps.
This has not been done in this application. A resident of India staying a person outside the India. This is the procedure to be followed.
You will grant you liberty to file afresh, get your, because this we are not going to keep on record, Mr. Vishwas. Issue. This appeal is directed against an order dated September 27, 2024, passed by a learned judge of this court in WPA 2157 of 2024, bracketed as Srimati Annesha Ghosh, ANWESHA, Annesha Ghosh versus the state of West Bengal and others, in which, the present, sorry,
Till Monday, madam.
what Monday?
Are we dismissing it?
On that ground,
With the liberty, madam.
yes. You were respondent number 7
Yes,
in the writ petition?
Yes, sir.
In which the respondent number, the present appellant was the respondent number 7. Is the call. Stop. Is the respondent number 7. Stop. The order impugned is interim in nature in the sense that the writ petition is still pending before the learned single judge. Stop. You were not represented before the learned
No,
single
madam.
judge.
The order was passed in the morning, I received the summons in the evening.
Go back to the learned
Yes,
single judge.
he is already in.
We'll grant you that liberty.
Yes. Madam, grant us the liberty.
Why lose a forum?
Yes. Madam.
Stop. Try করে দিচ্ছি। কি করে কি approach করবো? আমাদের approach করেছি। কিন্তু কেন আমাদের approach করেছি। কি হলো? হ্যাঁ, retreat is still pending, huh? Paragraph. We see we are not inclined to entertain this appeal primarily on 2 grounds which have nothing to do with the merits of the case. Paragraph. Firstly, the memorandum of appeal, memo to the lawyer signs the memo, normally?
Yes, yes.
The stay application filed in support of filed in the appeal has been affirmed by the appellant's father without there being any document showing his authority to affirm the affidavit in support of the stay petition on behalf of the appellant. Stop. Secondly, we see that the order impugned was passed in the absence of the appellant herein. Stop. The appellant says that he received notice of the writ application after the order was passed. Stop. Whatever the reason be, the fact remains that the appellant was not represented before the learned single judge when the order impugned herein was passed. Paragraph. Therefore, we are of the view that the appellant should approach the learned single judge with an appropriate application. Stop. We therefore dispose of this appeal without entering into the merits and granting liberty to the paragraph we therefore to the appellant to approach the learned single judge with whatever prayer he may have, in accordance with law. Appeal and stay application both disposed of. Grateful, Lordship. Hey, you have a delay, there's a delay application.
Yes, yes, can too. Can
No,
too.
ওই সব কটা ডিসপোজ অফ করে দেবো। আমি দেখছি এন্টারটেইনই করছি ওই তো এন্টারটেইনই করছি ডিলে অ্যাপ্লিকেশন তো সেই বাবার সই করা হবে।
Grateful.
Lordship,
My lord, in this matter, I beg to appear before your lordship through virtual mode, your lordship.
My lord, I am praying for leave to my lord appear before the honorable court, my lord, through virtual mode, my lord.
My lord, today I am.
My lord, am I audible, my lord? Am I audible, my lord?
You are appearing for whom?
I am appearing on behalf of respondent number 5 and 6 by filing wakalat.
My lord, in this appeal, my lord, an application under section 5 of the Limitation Act has been filed, my lord, for condonation of 129 delay in filing the appeal, my lord.
Who is for the, you are for the appellant?
My lord, I am for the writ petition of appellant before your lordship, my lord.
There was a direction upon the advocate on record of the writ petition to file an affidavit.
Your lordship, kindly see the order passed on 10th March 2020.
There was a direction to file. Who is Chakraborty? Response in form of affidavit.
Yes, that was the order passed on the 10th March, my lord.
There are some allegations against the.
No allegation is there, my lord, no allegation.
Who is Ms. Chakraborty?
She was appearing on the last occasion, my lord.
No affidavit has been filed.
No affidavit within 2 weeks, my lord. On the very next day, on 11th, we have sub copy, my lord.
So then
This
what
is
can we do?
129 days delay, your lordship.
Delay will condone, don't worry about delay.
My lord, your lordship.
all your direction, we were been said to comply the section 5. We have complied with the section 5 against the opposite party.
In the section 5, allegations have been made.
No allegation is there, your lordship. Kindly have a look to paragraph.
Whatever it is, it's the section 5.
My lord.
So, are the respondents opposing the prayer for condonation?
No, my lord.
So let us condone the delay.
Court was there because there are some allegations against the advocate.
Now, advocate on record has been served with a copy. If she doesn't file, what can we do? Let us dispose of the section 5. Read order dated March 10, 2025, paragraph. No affidavit has been filed by Ms. Chakraborty, learned advocate, pursuant to the liberty granted to her by the aforesaid order. Paragraph. We find there is a delay of 129
My lord.
days
129.
in presenting the appeal. Stop. Causes shown being sufficient, the delay is condoned. Which can is this?
So that is my lord, can number 2, your lordship.
The can 2 is disposed of. Now let us see the impugned order.
My lord, your lordship. My lord, may I show it, my lord, page 98 is the impugned order in the application for stay, as your lordship.
Allow us to read it.
My lord. Sorry, my lord.
Memorandum to know, memorandum is memorandum of appeal. Mr. Panda is for the College Service Commission.
My lord, I am appearing on behalf of the respondents college service commission.
Yes, what is, me? What is wrong with the order?
Yes, my lord, I am coming to that, my lord, your lordship. Lord, I shall invite my lord's attention to page, my lord, of my stay application, my lord. Page 92, your lordship, kindly have a look to page 92.
Yes.
The lordship will find, my lord, this was relied upon by the petitioner appellant, and the order passed by the honorable single judge, placed its reliance. Your lordship will find that in the paragraph 4, your lordship kindly, paragraph 4 of this is government order dated 8th July 2019. Page 92, your lordship, bottom, no curtailment of existing percentage of reservation for scheduled caste can be made in this regard. Hence, if no suitable candidate with benchmark disability is available for filling up 32nd vacancy, then said vacancy will be first be filled up by a SC candidate, scheduled caste candidate with other benchmark disabilities by interchange among the categories as mentioned in paragraph 2A, C and D with explicit and prior permission of the appropriate government. If there is no person with disability available for the relevant vacancy in that year, the employer then only shall fill up the vacancies by appointment of a scheduled caste person without any disability with approval of the appropriate government. So, my prayer would be before your lordship. The honorable single judge placed his reliance upon Milord, paragraph 3, your lordship. If any
Is your client a person with disability?
my lord, scheduled caste person with disability category B, my lord. He participated in the selection process for the post of assistant professor in English, and his name was, my lord, empaneled as successful candidate at serial number 2. So, my lord, what has happened now, my lord, I am still now not been employed. My name has not been recommended by the commission, and I am not favored with appointment letter. Although this one of the candidate did not refuse to join in a scheduled caste PWD person with disability, my lord, A category. So my submission was before the honorable court. Now before your lordship, my lord, that the honorable single judge placed his reliance on paragraph 3, and my respectful submission would be paragraph 4 is applicable in my case, my lord. This is very, my lord, Inoka's prayer before your lordship. Kindly have a look to that.
You are for?
Appearing virtually.
Yes, Mr. Panda.
My lord, my lord, can it be fixed on tomorrow? So I can, my lord, personally, my lord, appear before your lordship, because there is some documents and, my lord, some relevant regulation
Come
has to
tomorrow,
be
come
placed
tomorrow.
before your lordship.
Your lordship, kindly take it day after tomorrow, your lordship, kindly. Tomorrow is my medical checkup, my lord. Your lordship, kindly take it
Is
day after
directed
tomorrow.
against a judgment and order dated October 1, 2024, whereby the appellant's writ petition being WPA 2054 of 2024 was in effect dismissed. Stop.
My lord.
Paragraph. The appellant oblique writ petitioner says that he is a person with disability dash the PWD bracket A, capital A category, capital bracket A, capital A, the bracket close kore category. Stop. He relies on clause 4 of a notification dated July 8, 2019. government order call 2019 and in clause 4, comma, issued in exercise of power under section 34 bracket 1 of the Rights of Persons with Disabilities Act, comma 2016. Stop. Clause 4 reads as follows. Hey, running page 92. দেখো mark করা আছে। হ্যাঁ, clause 4টা দিয়ে দিই। Paragraph learned advocate for the appellant says that there is a vacancy in PWD bracket A bracket close category because of non-joining of one of the merit listed candidates. Stop. The aforesaid government order entitles him to be appointed in that vacancy. This is your short case.
My lord, your lordship.
Paragraph learned advocate for the School Service Commission.
No, my lord, College Service Commission.
Sorry, College Service Commission seeks a day's accommodation. Stop. Paragraph lists this matter once again. Friday date diye dao. Comma retaining its position.
Deeply obliged.
I'm grateful to deeply obliged to your lordship.
Condonation আছে নাকি এটা? হ্যাঁ, can to এই চলে গেল কোথায়? Can to হয়ে গেছে? ওটা হয়ে গেছে disposed of?
Twenty-six, my lord, I apply for the writ petition or appellant, my lord. I am for the WBACDC. May I file the affidavits of service, my lord? There are two sets of affidavits because the service upon the private respondent initially was not complete. Subsequently, it was again sent, my lord, it is still not complete.
Then, if it is still not complete, then how do we proceed?
The writ petition before the learned single bench also, my lord, none had appeared for the writ petition, for the
In spite of
yes.
service, if they don't appear, then there's no problem.
Yes, but here, my lord, I'll be candid, my lord, the service.
No, then try again. What can from the affidavits of service filed in court today, comma, it appears that the private respondent or many
Respondent number 5, one.
that the private respondent number 5 has still not been served. Paragraph, let service be effected on the private respondent and fresh affidavit of service be filed in court on the next date. List the matter on next Wednesday. Deedo.
My lord, item number 27, there is a defect.
Which one are you waiting for, Mr. Chaudhary?
Defective on the next matter 29.
I see.
My lord, there
This
is
is
section 5 application, we need to serve, my lord. My lord, kindly fix it on Monday, I will serve and come.
Section 5. Deal. The cause list indicates that there is a defect in this application. Stop. In this appeal. Stop. Learned advocate for the appellant says that appellant says that there is a delay in presenting this appeal. Stop. You have already filed an application. Stop. The appellants have filed an application for condonation of delay. Paragraph. Let that application be served on the respondents and affidavit of service be filed on the next date. Stop. List this matter, paragraph. List this matter once again on Monday date.
I'm for the writ petitioner's lordship.
You are for the writ petition?
Lordship. They are the Siliguri Primary School Council. They filed this mandamus appeal, lordship.
Yes.
I am for the appellant, my lord.
Taraprasad Haldar is appearing virtually on behalf
My lord, I am
of
for the appellant, my
the
lord.
appellant.
My lord, prior to they start, my lord, they already have complied with the order of the learned single bench, lordship.
Then
This is the
Of
copy
course,
of
my
the
lord. That
notice
two
that I have
portion, my
received
lord.
for hearing, and hearing has already been done, lordship. No.
Two portion, my lord.
Let it be dismissed, lordship, with
I am
cost.
here for the second portion. My lord, can you see the order?
They have already complied with this order, lordship.
hearing has already been held.
Yes, my lord. I have
Yes, yes, yes.
appeared in the hearing,
In
lordship.
terms of the
I am
order,
waiting for
half
the
portion was complied with, my
We
lord.
can't
But I-
hear him anyway, please.
So decision has to be taken with
Lordship.
regard to that hearing.
lordship.
What was the order passed?
Lordship, I was
Payment of A
My
category.
lord, I am
case-
the appellant. Kindly allow me to submit, my lord.
Yes. What is the order passed?
Kindly see the order. Page 78, my lord. Starting from page 78.
Sir, can you hear us?
Yes, my lord. Yes, my
You,
lord, I am here.
the writ petitioners had made a representation to the appropriate authority to the effect that they are entitled to receive A category pay scale as assistant
Yes, my
teacher
lord.
in government-aided primary schools. Now, all
Yes, my lord.
that the learned single judge did was to direct the competent authority to grant hearing to the writ petitioners and take a decision in accordance with law. Notice of
In the
hearing
light of
was
the judge.
issued and
My lord,
hearing was granted.
Lordship.
Now what remains is only for the authority to pass an order.
Lordship.
So at this stage, why should we entertain your appeal?
My lord, kindly see the order postal, my lord. Page 79. Twofold order, my lord.
Passed in
Passed
terms
in
of
the-
the Honorable
my
Division
lord,
Bench's
this is-
order, lordship. So learned single bench has rightly followed the order of the learned Honorable Division
There
Bench.
is no mandate after all.
Yes, my
Yes,
lord.
lordship. And
Only
now they have challenged.
They are to
My lord,
take
kindly
a
see the
decide
order.
this.
Yes, lordship. It's a frivolous
Kindly
appeal,
see
my
the
lord.
order, my lord,
Whoever
page
is agreed,
79, my lord.
you have the right to challenge.
My lord, kindly see the
In terms of the judgment of the Honorable Division Bench, that order was passed, lordship. So,
yes, my lord.
and accordingly, they
I
have
have no
complied that
hesitation,
order
my lord,
and give the
to act
notice to the
quickly
hearing.
in terms of the order passed by the division bench. But the next portion, my lord, kindly see the next portion, my lord.
We
Page
have read
80
the
in
order,
the
sir.
event.
Firstly, this is impossible. This way, no hearing can be held. We can't hear
Yes, my
half
lord.
of what you see. Sir, you understand there's nothing in this appeal. It has been, the order has been carried out or 75% carried out. What remains is for passing an order, reasoned order. You may well reject his representation. The
No, my lord.
trial judge, the learned single judge, has not bound your hands in any particular manner.
Can it be done, my lord? Kindly adjourn.
My
the
lord, next
matter.
portion, my lord, kindly see.
No.
Let me take some instruction. my lord.
What instruction will you take?
Only for one day.
Whatever is there, he
Can
has
it
to
be on
pass it in
tomorrow?
that order.
My lord, kindly see the.
Come back
My
tomorrow.
lord, kindly see the
All-
order for a moment, my
Your
lord.
learned friend is saying hearing has been held.
Yes,
Lordship, lordship. The date was fixed on 19th.
Yes, my
If
lord.
that be so, then what remains? Come back tomorrow. This appeal is directed against a judgment and order dated January 22, 2025, whereby a learned judge of this court disposed of a writ petition of the private respondent's hearing, being WPA 2547 of 2024, by passing certain directions. Stop. Paragraph, learned advocate for the private respondents / writ petitioners says that this appeal is not maintainable since the authorities upon whom the direction was passed, have complied with the directions. Stop. Paragraph, learned advocate for the appellants seeks a day's time to obtain instructions. Paragraph lists the matter, calculate date thou under the heading for orders. Stated এটা the appearance দিয়ে দাও ওটা bold capital এ underline করে স্টেটটা দিয়ে দাও
My lord, one minute, my lord.
টাইম দিয়ে দেবো না টাইম নেই না
Lordship, in this matter, I'm appearing for the petitioner respondent. There was a direction to file opposition.
what opposition to the stay application
Section 5 application.
how much delay
Malad, there is a delay of 775 days. Malad, may I indicate?
775
Yes, Malad. May I indicate, Malad? Kindly see the order dated, Malad, 11th March.
Chaudhary, I believe he is seeking extension of time.
Yes, Lordship.
Malad, the
Petitioner is
extension of
85 years
Malad,
old, Lordship. He is suffering
Malad,
from
the
heart disease.
extension of time, Malad, kindly see from the date of reference, Malad, till the adjudication and before the learned district judge and before Malad, the learned single judge, Malad, we are not represented. We are not made a party. We filed a recalling application before the learned single judge, Malad. That is still pending. Now, Malad, in this court, under the Malad threat of contempt, the payment was made, Malad, under the gun shell, Malad. So, Malad, kindly see that, Malad, my event, the 11th March 2025, there is a direction to file an affidavit within a period of 2 weeks, Malad. They have chosen not to file.
He should have filed by the 25th of March. Today we are on the 2nd of April, 1 week out of time. We'll grant you 1 more week, sir, not more than that. Do whatever you like. Do you need to file a reply to that?
Malad, we have explained the each and every day delay. Because why the government, the state undertaking body could not make an application in time, because we were not represented.
Mr. Chaudhary, if you know us, we will, whatever the delay be, we'll probably condone it. But since the coordinate bench has granted time to him,
Yes,
we only grant him 7 days more to file it.
2 days, Malad, Wednesday. Malad, let them come up with it on Monday, Malad.
Come up by Monday. This, you wish to deal with that? No.
I don't think. Let me see if they can supply me in advance.
We'll grant you liberty if you feel like filing, file a reply, or else don't file.
Yes.
Read order dated March 11, 2025. Stop. By that order, a coordinate bench had directed exchange of affidavits on the application for condonation of delay filed by the appellants. Stop. There appears to be a delay of 775 days in presenting the appeal. Paragraph, learned advocate for the one writ petitioner or many?
One.
For the respondent number 1 oblique writ petitioner seeks a little more time to file affidavit in opposition to the condonation application. Stop. Let such opposition be filed by April 7, 2025, with advance copy to learned advocate on record for the appellants. Stop. The appellants will be at liberty to file their reply, by Wednesday or by.
Well, if they supply me in advance.
We have said so, but if they don't, if they give you on Monday.
Friday.
Friday, well, but then I will come up on Monday, Malad.
You will file by Monday.
I will serve
by Friday. Oh, very well. So, তাহলে ওটা reply by Monday. ও না শোনো তাহলে with advance copy যেখানে বলেছি, to learned advocate on record for the appellants by Friday date.
Not appellate, respond.
No, advance copy to your.
But the advance copy to.
By Friday date, though. The appellants will be liberty to file by April 7. List the matter on April 8.
7th itself, Malad, we will come after 7th.
Very well. List the matter on April
Yes, good.
70 list করে দাও।
49 চলো যাচ্ছি।
I am for the respondent writ petitioner.
Lordship, item number 30, I am praying for a day's accommodation, Lordship. Just one day accommodation, my senior will be there physically.
Wednesday, my lord, next Wednesday. Actually, my lord, sir, no due certificate was asked to be produced by us, by the last coordinate bench, by way of order dated 11th of March 2025 from the PF authorities. We have applied the same. We will have it in a day or two, my lord. So, may kindly.
You are for the writ petitioner.
I am the respondent writ petitioner. The order is in my favor. PSNL is in appeal.
Lordship, in this matter, Lordship, I'm praying for a day's accommodation because my senior has to make some submissions. There is also a CAN application regarding
Your learned friend for the writ petitioner wants it next Wednesday.
Lordship, we have to make some submissions, Lordship, actually. That's the
To
reason.
make your submission on Wednesday, who stops you?
As your Lordship pleases.
Hey, dekho. The appellants seek accommodation. Paragraph, learned advocate for the respondent oblique writ petitioner requests that this matter be listed on April 9, which will give him, which will give him sufficient time to produce the no dues certificate
from the PF
from the Provident Fund authorities, as had been directed by a coordinate bench.
By the order dated 11th of March.
By order dated March 11, 2025. Paragraph, list the matter once again on April 9.
My lordship.
Grateful, Lordship.
My lord, I am seeking for a day's accommodation.
Why?
My lord,
Wednesday is a good day, lucky day. Wednesday is a lucky day.
that actually my led by Mr. Shondip Mondal, he will argue the matter. In that regard, I am asking for a day's accommodation. My lord.
On the prayer, Apurvo, on the prayer made on behalf of appellants, let this matter stand adjourned for the day.
Next week, because I have not got the copy. I am for the writ petition.
My lord,
they have supplied me through email, but some error occurred in opening it. So any hard copy may be given. Text will be given. And I can, so that I can find provided copies in the meantime.
No, let them open their case, let us see.
So hard copy.
So give him a copy today, it will be listed tomorrow.
We have already served him in through by email, but we will give him the provide in the hard copy.
Give him today, it will be listed tomorrow.
Yes, ma'am.
Can it be not the day after tomorrow?
Very well. Hey, adjourn for the request and adjourn and be listed on Friday date.
Actually, the classification that I have mentioned in the matter, it's not right, it's not correct. There is some defect in that classification. And a liberty may be granted to correct that classification of the people.
Leave is granted to learned advocate on record for the appellants to correct the classification made on the cover page. Classification mentioned on the cover page.
This matter, Mr. Mazumdar is appearing, my lord. Yes.
Friday.
Great.
For a day's accommodation.
Why? On the prayer. Adjourn for the day. Next. 34.
34, my lord. I am for the respondent number 6, my lord.
I am for the respondent primary board.
Yes,
That
yes.
there was a direction to file or affidavit to their application.
To a restoration application.
Yes, I'm for the appeal, Lordship.
Because
This is a restoration application, Lordship. I have filed within the time, but they have raised objection to
How
file
many days
opposition.
delay?
They have filed opposition.
I have filed my opposition. My lord, 2023, it was dismissed. 25 mentioned for restoration, my lord. 2 years they sat tight over the issue. We have filed
But I
our
have
opposition.
filed the restoration within the time, Lordship. Within a week, I have filed the restoration application.
Yes, affidavit in opposition you have filed.
My opposition is pending and I'm praying.
How many days delay?
1 week.
There is no delay, Lordship. There is no delay. I have filed the restoration application within a week.
No, when, how many days delay?
Delay नहीं तो कुछ. File पूरे आज
The matter was dismissed for default on 3rd October 2023. Then 12th October, I have filed a restoration application. Therefore, I have mentioned several times, Lordship, but matter could not be listed. Then
Why don't you fight out on merits, sir? Why are you opposing a
There is
restoration?
no delay in filing this restoration application.
they have opposed the restoration application, Lordship.
So,
Wait.
Yes, what is your ground for not appearing? What have you said?
Lordship, when the matter was called for, Lordship, I could not follow the list, Lordship. Therefore, I'm not able to attend through the online, Lordship. I have mentioned in paragraph 4, Lordship.
Mr. Ghosh, fight on merits. What are you for fighting, opposing this? Filed within time. Now your learned friend on the other side is saying didn't mention for 2 years. It was the court's duty to take it up after all. It was filed.
that is not
Grateful,
a delay.
Lordship,
In
grateful.
jurisdiction, there is no delay.
So that's why I have kept my speech really low.
Issue.
The lowest I can.
My lord, one indulgence, my lord. In all
Yes.
orders, my name is recorded that I am appearing for respondent number 5, but I am appearing for the respondent number 6. That may be.
ठीक है.
Grateful, Lordship.
देखो, this is an application for restoration of MAT number 22 of 2019, which was dismissed for default on October 3, 2023. Stop. Paragraph. We see that the application was filed well within time, on October 12, 2023. Stop. Paragraph. The respondent number 6 has filed an affidavit in opposition. Stop. We have gone through the same. Stop. Paragraph. We find from the restoration petition that sufficient ground has been made out, sufficient explanation has been given for non-appearance of learned advocate for the appellant on the day the appeal was dismissed for default. Stop. Paragraph. Hence, we are inclined to and hereby do recall the order dated October 3, 2023 and restore the appeal. Is there any connected application or only the appeal?
There is an application for stay.
The appeal and the connected application to their original file and order. File and number. Stop. Paragraph. Be it recorded that Mr. Arnab Mukherjee
Yes, ma'am.
appears for the respondent number 6 in these proceedings and not for the respondent number 5 as was erroneously recorded in the orders dated October 3, 2023 and February 14, 2025.
Grateful, Lordship. Great.
Paragraph can is disposed of. Can 3 can 3 is disposed of. What is can 1 and 1 is?
Other is my stay application in connection with my appeal.
It ever came.
Shamim.
And 2 can 2?
And Lordship, there is an appropriate order, Lordship.
Very well. Let the, when do you want the main matters to be listed?
Milord, it can be taken up before the next circuit because
Yes, next circuit.
if Milord directs for paper books to be filed, and I don't.
No,
think
paper
that-
books, there is an application, it can be disposed of, blood.
Applications can be disposed of.
No, not now, blood. There is an order of stay is there, blood. Blood, it can be.
Order of
allowed,
stay
blood.
is there.
Already, blood, there is an order of injunction passed by this revision bench, blood. In this
In
appeal,
which
blood.
proceeding this matter was dismissed?
Yes,
Prior
blood.
to
Before
dismissal, Milord, there
dismissal,
was
blood.
an interim order passed by this honorable court.
I see.
On the
Now,
record
whether
of-
automatically it stands restored or not, we don't know.
Blood, kindly record that, blood.
What?
That the interim order, whatever was there, blood, is restored, blood.
Where is that interim order?
Blood, Justice Horish Tandon's division
No,
bench
Justice Tandon.
passed it out. Blood.
Tenth of March 2022.
10th of March
2022.
2022.
22.
Since it was there, let this stand restored. এটা লেখো তারপরে এটা নাও appealটার can দুটো নাও নিয়ে দেখো let the order dated interim order dated March 10, 2022. Have you exchanged affidavits on the applications? No.
Yes.
Affidavits have been exchanged.
Yes.
March 10, 2022, stand reinstated and continue till the end of this month or until further order, whichever is earlier. Paragraph, list these matters before the next available circuit.
Milord, can direct filing of informal paper books, Milord, all the applications can
Hey.
happen disposed.
Yes, my lord. That will be easier for.
Let it be listed in the next circuit or in the next week.
Next circuit.
Great.
Can treated disposed of.
By 35 lordship, I am paying for next week on Wednesday.
Why?
Conducting advocate is the.
Huh?
Conducting advocate is the. I'm not.
He wallet receive Oh. On the prayer made on behalf of the appellant oblique petitioner, let this matter stand urgent for the week.
What's the Wednesday lordship?
Stand urgent and be listed again on April 9. Urgent for the week, likho na, urgent.
I am for the appellate right. Appeal filed within time for admission. It is.
Why does it say defective then? The cause list says defective.
I have seen the, what,
देखिए appeal to the.
Can one is for what?
can one is for, section 24, maintenance, pending right, and, another one is for injunction. So that respondent be restrained from marrying.
Note the defect, take steps to remove it. It is mentioned what the defect is. Leave is granted to the advocate on record for the appellant to remove the defect as noted by the stamp reporter. Paragraph lists this matter once again on Monday date. It's an appeal from decree. It has not been classified as an appeal from decree. That is the defect.
Maybe that is the written order, judgment and order.
Anyway.
Just like. Lordship, so far my knowledge was that decree has not been drawn up by the.
No, but still it is an appeal from decree.
We have to write decree.
This matter, I am happy for the petition laid by Paramita Mukherjee.
My lord, item number 37. Item number 37, I beg to appear on behalf of the appellant, my lord. This appeal has been preferred challenging judgment and decree from a matrimonial suit, my lord. The judgment and decree was passed on 23rd of September. It is within time, my lord.
The appeal
My
is
lord,
within
we kindly be
time.
pleased to admit the appeal, my lord.
কিছু
Within
শোনা
time, my
যাচ্ছে।
lord. Within time. My lord, it is within time, my lord. It is within time.
Have you served?
No caveat is there.
No, my lord, not yet. Not yet.
Very well.
Are you praying for any interim order?
No, my lord, no application is pending. No application has been filed.
You are the wife.
I'm the wife.
Whose suit was it?
It was the wife
Wife
who had
asked for
filed the matrimonial suit.
wife asked for
Wife
divorce.
asked for divorce. Wife asked for divorce
Dismissed.
on the
Dismissed.
ground of dismissed, my lord.
Lekho. This is an appeal from a judgment and decree dismissing the appellant's suit seeking divorce. Stop. Paragraph, the appeal is formally admitted. Stop. তারপর usual যা হয় করে দাও। Trial court records আছে, তুমি দেখে নিও, দেবজ্যোতির কাছে আছে। Issue notice, trial court records, requisite number of paper books. 8 paper books within 8 weeks. List the matter after 8 weeks.
My lord, if any messenger cost is to be deposited, then I can do that. For lower court record, if any cost is to be deposited by special messenger.
That you can always ask your advocate on record to contact the department. If they say, deposit the cost.
My lord, my lord. I'm grateful, my lord.
Item 38, I'm praying for 2 days accommodation. So it will be fixed on Monday, my lords.
On the Monday,
Monday.
on the prayer made on behalf of the appellant. Come on, let this matter stand adjourned and be listed again on April 7.
Great.
Chalo.
Lordship, item number 39, Lordship, I'm led by Mr. Amlesh Rai. Lordship, he's on his legs before court number 2, Lordship. Lordship, you can kindly be allowed to take it up next week, Lordship.
Going to same agita jete bolle?
Lordship, if it can be kindly be fixed on Wednesday, Lordship.
Monday.
Lordship, Monday he'll be appearing before the principal bench, Lordship. That's right.
What can be done, sir? Next.
Grateful, Lordship.
My lord, kindly keep the matter on Monday, my lord. I've been instructed by my learned senior.
Same order.
Yes, I'm praying for 2 days accommodation. So if you on Monday, I'm great. 41.
Forty-two, madam, I'm praying for not this week.
Same order. मैं तो बोल लूं क्या order.
Yeah, for the application.
What is the defect?
Well, that's there's a delay.
Have you filed a section 5?
Yes.
You have to serve the section 5.
Yes, I've already served.
Where's the affidavit of service? How many respondents are there?
Malad, 6, I believe. 6 respondents.
6. All have been served.
Well, only in respect of the respondent number 3 that has come back with the cannot be located with the endorsement. It's the same address which I found in the it's in the plaint also. It's the same address.
You were the plaintiff.
Yes, my lord.
Your suit was dismissed.
No, this is an appeal from the injunction, refusal of the injunction. I didn't bring it. Miscellaneous appeal.
Which are the grounds?
Pardon?
Which are the grounds?
Yes, my lord. My lord, I have categorically stated what the my lord takes a look at the impugned orders. It's annexed to the
The defendants in the suit, the respondents in the suit, the opposite parties here, they were represented through one counsel before the single counsel.
It was in the ad interim stage also, my lord.
So in the ad interim stage, it was refused.
It was refused. Challenging that ad interim refusal.
And thereafter, the date was fixed on 5/12. It is still
filing of
pending.
summons. It's still pending.
Go and thrash it out there, ex parte stage, ad interim stage.
I'm concerned.
What is the relief you sought? In the ad interim
Well,
stage?
ad interim from changing the nature and character of the suit property is a suit for recovery of possession and from alienating the suit property in any manner. Yes, that is what.
We'll give you grant you a status quo
Lordship.
and ask the trial court to dispose of this application.
Order.
Hey. This appeal is directed against an order dated September 26, 2024. তার আগে করো। Affidavit of service filed in court today be kept with the records. Stop. It appears that all the opposite parties excepting
Respondent number 3.
the OP number 3 have received notice of this appeal. Stop. However, since all the opposite parties who are defendants in the suit pending before the learned trial court, are being represented through the same counsel, we do not deem it necessary to adjourn this matter.
Well, I believe that has to be.
If not, sir, then you will have to serve.
But that is pending before the, we have already filed the summons. SR is still pending before the trial court.
Then you'll have to make some effort to serve.
Well, it's the same address in which I served.
That is true. That is true.
All the respondents have been served.
Very
Which is not complete.
No, all the respondents have been served. Only the respondent number 3, it came back with that particular endorsement. Cannot be located.
কি বললাম? না, ওটা কেটে দাও, সেন্টেন্সটাই কেটে দাও। এটা শেষ হলো কোথায় এসে? Stop. However, since the order sought to be impugned in this appeal was passed ex parte in the absence of the opposite parties herein who are defendants in the suit, we have taken up this matter. Stop. Nobody appears for the opposite parties. Paragraph. This appeal is directed against an order dated September 26, 2024, whereby the learned trial judge 2024 passed in title suit number 213/2024, whereby the learned trial judge refused to pass an order of interim injunction at the ex parte stage, ex parte ad interim stage. Order of injunction, interim at the ex parte ad interim stage. And issued notice calling upon the defendants in the suit to show cause why interim injunction should not be granted against them. Paragraph. The plaintiff claims to be the purchaser and owner of the suit premises. Stop. The plaintiff's case is that taking advantage of its absence from the premises for some time, the defendants, bracket lekho, opposite parties herein, bracket close, forcibly took possession of the same, of the suit premises, and illegally made construction thereon. Stop. The plaintiff has filed the suit for declaration, recovery of possession, mandatory and perpetual injunction, and consequential reliefs. Stop. In aid of such reliefs in the suit, the plaintiff applied for interim injunction, which was refused at the ad interim stage. Stop. Hence this appeal. Paragraph. We formally admit the appeal. Stop. Next. We do not see that any useful purpose will be served if the appeal is kept pending before us. Stop. The injunction application of the plaintiff is still pending before the learned trial court. Stop. We direct the learned trial court to dispose of the injunction application upon hearing both parties within 3 months from the date of communication of this order. Stop. Paragraph. Till the disposal of the injunction application by the learned trial court, comma, the parties are directed to maintain status quo
Grateful.
as regards the title, comma, possession, comma, nature and character of the suit property.
Grateful.
Huh? Thus disposed of.
Well, delay is to be conducted.
How much?
26 days, my lord.
Where, which can?
Can one.
Can one causes shown being sufficient. This is an application for condemnation a delay of 26 days in presenting the appeal. Stops, causes shown being sufficient. ঠিক আছে? Disposed of. এটা can one করবে। কত নম্বর আইটেম ছিল এটা? হ্যাঁ 43 আর can 2টা হচ্ছে can 1টা করে ডিসপোজ অফ করে তারপরে ম্যাট আর হ্যাঁ একসঙ্গে নেবে ম্যাট নয় এফএমএটি হ্যাঁ একসঙ্গে নিয়ে এই অর্ডারটা করে ডিসপোজ অফ করে দাও।
Grateful.
ঠিক আছে তো
Lordship, I have a Passover matter item number 2.
Sir, please don't mention in the middle. Issue.
Lordship, kindly let the matter appear
On the prayer, right? There's a defect. Find out what the defect is.
Section 5 is there, but it has not been heard yet.
Oh, I see.
It has been mentioned.
I'm appealing for the petition. Section 5 has not been filed. I'm paying for.
Learned advocate for the appellant says that there is delay in presenting this appeal. Stop. He seeks a little time to file an application for condonation of delay, paragraph. List this matter once again next Wednesday, did the other? Next Wednesday. So in the meantime, if any application is filed by the appellant, comma, the same shall be listed along with this appeal.
But not the KPH. I served the applications and everything upon the receiver lawyer advocate of the KPH.
Where's the affidavit of service?
So this is the receipt.
Affidavit of service.
Receipt by the advocate.
Affidavit of service. File an affidavit of service. Come back day after tomorrow. Learned advocate for the appellant says, that because there was a caveat, comma, service has been effected on the respondents. Stop. Let affidavit of service be filed on the next date, paragraph. As requested, comma, let this matter be listed again on April 7.
Okay.
I'm praying for not this week, my lord.
ওই যেটা ছিল not this week যেটা ওই order. নেই চলো।
Lordship, I am for the appellant.
Yes.
Lordship, can one is the application for substitution wherein the appellant number 1 has to be substituted by the appellant number 2, 3 and 4 who are the legal heirs of the appellant number 1. And the substitution application has been filed within the time period, Lordship.
No, appellate numbers 2, 3 and 4 are already on record.
Already on record, yes, Your Lordship.
Then where's the question of substitution? Only recording the death. Do you understand?
Yes, Your Lordship.
If the legal heirs are already on record, there's no question of
Yes.
substitution. Are you sure that these 3 persons are the only
Yes,
3?
I have filed the legal hire certificate along with my application. That is the
Are you
annex. to-
sure that these 3 persons are the only 3 legal heirs?
Yes, Your Lordship.
Very well. Then who have you served?
Yes, Your Lordship.
Have you served? Who are you appealing for?
For the appellant.
Have you served a copy of this application on the respondents?
Particularly this application, no, Lordship.
Yes, respondents have entered appearance in this matter. Is there any caveat?
No, Lordship.
The
There is no
appeal
caveat.
papers have not been served on the respondents.
Not yet, Lordship.
Please declare the substitution টা কি এখন করে দেবো নাকি আদৌ সেই এই তো very well. Issue. Can one ওটাতে অর্ডারটা করো? This is an application for recording the death of the appellant number 1. Stop. Learned advocate appearing for the appellants tells us that the appellant numbers 2, 3 and 4 are the only legal heirs of the appellant number 1. Stop. Hence, there is no question of substitution. Stop. We only record the death of the appellant number 1. Stop. Paragraph, let the name of the appellant number 1 be deleted from the cause title of the appeal papers. Stop. The department shall make appropriate amendment to the cause title of the appeal papers within a fortnight from date. Stop. Paragraph can 1 is disposed of. Paragraph. Once the cause title of the appeal papers is corrected, let copies of the appeal papers be served on the respondents and affidavit of service be filed in court.
Grateful,
Stop.
Lordship.
List the matter before the next available circuit bench.
Grateful, Lordship.
Canter disposed of. Next. Me क्यों छाड़ो? You me 50.
এটাই 51 51 এটা 87 Worship, I filed the application for under section 24 of Hindu Marriage Act for maintenance pending act.
Which one is that? Can 5?
Can 5. And can 2 is injunction against the husband, which already been granted, and that is extended up to 5th May, 5th March, 5th May, sorry.
So can 5, have you served it?
Son, exchange of evidence is also done.
Oh,
On earlier occasion, Honorable Justice Tandon directed me to file affidavit of assets as per format that I have prepared. Both the parties we were directed on earlier occasion, they have not appeared. Today they have also not appeared.
so you are for the wife, you are for the petitioner.
For the wife, I am getting maintenance by virtue of the order of Honorable Learned James Darjeeling, that is rupees 7,000 since 2013. His salary was then 21,000, now 93,000. They have given that document also.
Have they filed,
Yes.
He has filed his affidavit.
They have shown, they have sharp copy upon me.
Do you know Mr. Mayank?
Mayank and Shubham. Both they were present. I think they left earlier. I think they have some other, it may be taken up tomorrow.
Very well. Day after tomorrow. Affidavit of assets and liabilities filed on behalf of the petitioner in court today, comma, in terms of this court's earlier order dated March 13, 2025, comma, be retained with the records. Paragraph, nobody appears for the respondent today. Paragraph lists the matter once again. Kalke date diye do. Inform them, tell them.
Lordship, I shall. Lordship, can it be fixed the day after tomorrow? Actually, let them prepare also a review of assets, I think.
Chalo.
Item number 52, Mr. Kuchati is appearing on virtual.
53.
52, Lordship.
52, my lord. My lord, 52, my lord, item number 52, my lord, I am appearing for the appellant state.
Yes.
My lord, in this matter, my lord, your lordship, kindly see, my junior is there. My lord, who would, my lord, place the, my lord, affidavit of service, my lord, by which, my lord, we sent twice to the, my lord, decree holder, my lord, the opposite party respondent, and in the address, which has been, my lord, mentioned in the degree, but, my lord, twice it has been returned. So, I humbly pray your lordships. Also, I directed our officer to collect the proper address from the concerned officer of the lower court, which, my lord, following the execution case. My lord, the same address they have supplied to me. So I humbly pray before lordships, in always it is, my lord, returning back with the reverse, not found or not the address is not proper. So I humbly pray, my lord, let the matters be published through paper, because, my lord, pasting service or, my lord, otherwise, my lord, it is not possible. So can it be, my lord, published? Send it in time, my lord. Twice I have sent it, my lord. Your lordship kindly see that.
By this impugned order, the additional district judge, he has made an award.
Yes, my lord. He has enhanced the award under section 18. My lord, land was
Enhance the award. Enhance the award.
Enhance the award.
Enhance the award. Okay.
Enhance the award, my lord.
Very well, Asho. Where is your affidavit of service?
Lordship, actually, affidavit of service.
It is not with your junior, sir.
I have handed over to him, sir. My lord.
Yes,
I handed over last occasion. I handed over him.
Yeah, unless you bring that, how can we? We have to take that on record. We have to say that it could not be served, and then we will grant you liberty to.
I apologize as well.
Grant you liberty for substituted service by paper publication.
Yes, or paper, my lord, through paper permission. My lord, I am requesting my learned friend, my lord, to hand over the same, my lord, on last, in the next date, my lord.
Ah, that's right. So give it when tomorrow.
Last occasion when I visited, my lord, physically to tomorrow, yes, my lord.
এক কাজ করো, tomorrow to be mentioned করো. To be mentioned. Yes. What is this?
Sir, this is an application, in the partition shoot. And there is a delay, a long delay of 4,778 days.
4,000?
And the defendants are, the respondents have appeared and they filed affidavit in opposition also. And that is on record also. And although the delay is long, but there are sufficient cause. They have mentioned.
Yes, so you will do it ex parte.
He has filed affidavit in opposition, but today he is not present.
Today he is not present, so you know who is appearing.
Lordship.
Inform your learned friend, not today.
Yeah.
Next. Next.
56. I am applying for the appeal.
Yes.
This is an appeal against a degree of dismissal of my partition suit. I am the plaintiff in that suit and should have been dismissed. The affidavit of service I have served on that.
Is can one for what?
Can one for the injunction application. So it was the ancestral property. My father was the owner of the property. And all the plaintiff and the defendants are the co-sharer. The plaintiffs have demanded partition, but the defendants came up with a plea that my father, during his lifetime, has gifted some property to the defendants. Gifted some property, not the entire suit property. Lordship.
How many defendants are there in the suit? Only one.
No, Lordship. 6 defendants. One A, they are numbered in that. Three sets of defendant, one A, one B, one C. In that way, they numbered in that plate.
This appeal is directed against a decree dismissing the appellant's partition suit. Stop. The appellant has filed, paragraph D, an application for application for injunction from the affidavit of service filed in court today, comma, which be taken on record, comma, it appears that the respondents have been served. Stop. However, nobody appears for the respondents. Paragraph. Let fresh notice of the
Twice or thrice it has been served.
Do you know which lawyer?
Yes. Lower court lawyer. Probably the lawyer who was conducting in the lower court knows.
See if he accepts service. Paragraph
Twice or thrice, we have served and.
Then what to do?
if they do not appear, they are not willing to contest. They are
No,
not- I
No,
am
try
just
once
because-
more. We'll pass a limited order today. Paragraph lists this matter once again next Wednesday. Stop. Till April 11, 2025 or until further order, let there be an order of status quo
Lordship,
as regards the suit property
which are character and
in respect of the suit property, suit property, as regards the ownership, possession, nature and character
Lordship, yeah.
thereof. Paragraph, let the appellant make another effort to serve the respondents or their advocate who appeared before the learned trial court in the event he is willing to accept service.
Lordship.
Hmm?
Grateful.
Don't you kindly fix the matter on next week?
On the prayer made on behalf of the appellants, let this matter stand adjourned and be listed again on, tell us, Monday, Tuesday? Monday date दिए दो.
In this matter, Lordship, I am for the appellant, praying for a leave, Lordship, to insert the present address of the respondent. As because on last occasion, we served the notice upon the respondent till the disposal of pending of this appeal, he left the house and we collect the present address.
Respondent's address is not mentioned in the appeal papers.
The appeal, but during pendency of this appeal, he left the house, shifted to another house, another address, Your Worship.
What are these three applications?
Can is for delay application.
Three cans. Can 1, can 2, can 3.
Can 1 is for delay. Section 5 is there. Can 2 is for stay. Actually, this appeal is against the decree of a matrimonial suit. And can 3 is for.
It was your suit.
No.
Your suit.
I am wife.
That I understand, madam, from the name, but whose suit was it? Who filed the suit?
Husband, Your Lordship.
And the suit was allowed.
Allowed.
The divorce prayer was allowed.
And decreed.
You have not served notice of this.
Served, but address change.
Address change. You found out the new address. Lekho.
Praying for leave.
Leave is granted now. Learned advocate for the Acha. This is an appeal against a decree whereby the respondent's suit for divorce was allowed by the learned trial court. Stop. Paragraph. Learned advocate for the appellant, appellant bracketed wife, bracket closed, says that when service of the appeal papers were attempted to be made, it was found that the respondent has changed his address. Paragraph, liberty is granted to the appellant to incorporate the new address of the respondent in the appeal papers and to effect service at such address. When should we keep the matter?
Next
Next
week.
List the matter next Wednesday. Serve all 3 applications on him.
Lots. Grateful. Lots.
Mr. Mojumdar will appear in this matter.
Friday.
Also.
Friday.
I'm for the appellant lordship. There is a defect lordship. Kindly 1 week's time to cure the defect lordship.
Huh?
Defect, cure
What
the
defect? What defect? Daw to file ta? Delayed by 2905 days. Dekho. As per the note of the stamp reporter, comma, there is a delay of 2905 days in presenting this appeal. Paragraph. Let this matter go out of the list. Stop. No, out of the list with liberty to mention. Stop. Let the appellant take appellants go away. No, appellant act take appropriate steps for removing the defect. ওই স্টেজেতেই উড়িয়ে দেওয়া নেই করেনি তো Section 5. What is can 1, can 2, sir?
Lordship, there is a, I think section 5.
Section 5. হ্যাঁ তো দাও কি প্রেয়ার গুলো দেখি কি ও তো কন্ডোনেশন পিরিয়ড রয়েছে তো তাহলে You have served.
No, Lordship, I am led by Mr. Gujari, is virtual mode, but now is offline.
এরটা কেটে দাও কেটে দিয়ে করো There appears to be a delay of 2905 তাই বলেছিলাম days in presenting this appeal as noted by the stamp reporter. Stop. An application for condonation of delay has been filed. Stop. Let service of that application be effected on the respondents and affidavit of service be filed on the next date. সামনের মঙ্গলবার লিস্ট করো
Lordship, kindly keep this matter on next week.
On the prayer made on behalf of the petitioner, let this matter stand adjourned and be listed again next Tuesday, Koro.
Seven. Nine.
68, my lord, I am for the petitioner. I'm praying for an adjournment in this matter.
Why do we list these matters then? If
My
nobody
lord,
wants to-
my
nobody,
lord is not audible.
nobody is
68,
interested
same
in
prayer.
doing. Chalo. Adjournment for how long? 2 months?
My lord is not audible, my lord.
I am not audible. Everybody can hear me here. যাকে চলো কি করা যাবে
68,
এগো
my lord, I
4:30
am for the
বাজে
petitioner. I'm praying for an adjournment in this matter.
Why do we list these matters then?
My lord, my lord is not audible.
Nobody is interested. কি বাচ্চু গুরু কারো বাচ্চু এই শোনো এসো 4:30 বাজে যাবো তো তুমি একবার শুরু করলে আর থামতে চাও না গট 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 করছো
69. I'm praying for an adjournment in this matter. My lord, my lord is not audible.
Why are you here
This was one matter tomorrow.
tomorrow?
I want to the respondent.
How is the weather in Calcutta?
Worse than this, far better. As soon as I stepped down, I told my clerk, there's a beautiful weather.
Yes.
And
So are you shifting to to this bench?
I think 25 to 30 years ago, when I was a student in British Council, Lord Flynn of Hadley had come down to deliver the Sarkar law lectures. And he started off by saying that I saw my dear friend PP, referring to Mr. Jinwal. When they landed in Delhi, the weather was very cloudy and very dark. But I find that that darkness is now gone in some light.
Correct, correct. Since you are here as well.
Lordship, my lord.